The next item of business is consideration of Business Motion 24379 in the name of Graham Day on behalf of the Bureau setting out a Stage 3 timetable. Could I call on the Minister to move this motion? Thank you. No other member has indicated they wish to speak. Therefore, the question is that motion 24379 be agreed. Are we agreed? Yes. We are agreed. Thanks. So, we're turning now to Stage 3 proceedings on the United Nations Convention on the Rights of the Child Incorporation Scotland Bill. In dealing with the amendments, members should have with them the bill as amended at Stage 2, the marshalled list and the grouping of amendments. And as usual, the division bell will sound for 5 minutes when we have the first vote of the afternoon. All votes will last 1 minute. Any member who wishes to speak in a group should press their button to speak as soon as I call the group. And members should now return or refer to the marshalled list. We'll start with Group 1. This is regulations under Section 3. I'll call Amendment 1 in the name of the Cabinet Secretary, group with Amendments 2 and 36, and the Minister Marie Todd, I think, to move Amendment 1 and speak to all amendments in this group.
Thank you, Presiding Officer. Section 3 of the bill sets out the UNCRC requirements which consist of text from the Convention and the first 2 optional protocols. Section 3 also gives the Scottish Ministers the power to modify the schedule in specific ways by regulation. It's important that the Scottish Ministers can modify the schedule in line with any changes to the UNCRC or its optional protocols, or if an optional protocol is ratified by the United Kingdom. It may also be appropriate to modify the schedule should the powers of the Parliament change in future. For example, by adding articles of the Convention which are not currently included due to reasons of legislative competence. This power is subject to the affirmative procedure, so there will be a high degree of scrutiny regarding its use. At Stage 2, I supported an amendment of Alexander Stewart's requiring consultation in relation to regulations under Section 3. Amendments 1 and 2, which I move today, are minor drafting changes to make the effect of the provision clearer. I support Ruth Maguire's Amendment 36, which would place on the Scottish Ministers the same consultation requirements that are included elsewhere in the bill. This would require Ministers to consult the Commissioner for Children and Young People in Scotland and the Scottish Commission for Human Rights prior to using the Section 3 power. This will ensure consistency between the duty to consult in Section 3 and similar provision elsewhere in the bill. I move Amendment 1 and I urge members to support it and Amendments 2 and 36.
Thank you very much, Minister. And could I call Ruth Maguire to speak to Amendment 36 and the other amendments in this group?
Thank you, Presiding Officer. Section 3 of the bill sets out the UNCRC requirements, which consist of text from the Convention and the first 2 optional protocols. It also gives the Scottish Ministers the power to modify the schedule in specific ways by regulation. Amendment 36 builds upon the amendments made at Stage 2 by requiring consultation with the Commissioner for Children and Young People in Scotland and the Scottish Commission for Human Rights when the Scottish Ministers make regulations under Section 3, in line with the other consultation requirements in the bill. That synergy and consistency seems both appropriate and necessary. I welcome the Minister's support for this amendment and move it in my name.
Thank you very much. And could I call Jamie Green?
Thank you. Just briefly to confirm, we will support all amendments in this group, but also specifically to commend the amendment by Ruth Maguire. We've heard, whilst this was an Equalities Committee bill, the Education and Skills Committee has heard frequently from the Commissioner, especially over the issues around the effects of lockdown measures on children and young people. Their inclusion in consultation is a welcome one, and I note that the Government has included this in Stage 3. We have a number of amendments throughout the debate this afternoon that we may oppose, that I will speak to as and when we get to them. But the majority of amendments this afternoon, we will be pleased to support.
Thank you very much, Mr Green. Does the Minister wish to add anything by way of winding up?
No, thank you, Presiding Officer.
Thank you very much. So the question is that Amendment 1 be agreed to. Are we agreed? Yes. We are agreed. Can I call Amendment 2, Minister, to move formally?
Moved.
Thank you. The question is that Amendment 2 be agreed to. Are we all agreed? Yes. We are agreed. Can I call Amendment 36, Ruth Maguire, to move?
Moved.
Thank you. The question is that Amendment 36 be agreed to. Are we all agreed? Yes. We are agreed. We turn now to Group 2. This is on the interpretation of the UNCRC requirements. Can I call Amendment 3 in the name of the Cabinet Secretary, grouped with amendments as shown? Cabinet Secretary John Swinney to move Amendment 3 and speak to all the amendments in this group.
My apologies, Presiding Officer. It's of fundamental importance that the United Nations Convention on the Rights of the Child requirements incorporated by this bill are interpreted and applied within the full context of the UNCRC itself, including the preamble and excluded provisions which cannot be incorporated within the powers of the Parliament at the present time. It is also important that they are interpreted and implemented using the rich sources of authoritative but non-binding materials produced by the Committee on the Rights of the Child where relevant. The courts can and do, as a matter of course, consider a wide range of sources of interpretation which are relevant to the cases which come before them. The purpose of Section 4 is to bring transparency to and to recognise the significance of sources which are fundamental to the understanding, interpretation and implementation of children's rights. The intention is that the bill promotes understanding of these sources and that their use becomes routine practice amongst public authorities, courts and practitioners in support of children and young people and the fulfilment of their rights. That is why we sought to address this at Stage 2, and other amendments were added to Section 4 by committee members. As we indicated during that debate, we were concerned that some of these amendments might have unintended consequences. In particular, as amended at Stage 2, Ministers are concerned that although Section 4.1 would only require the courts to take into account the sources where they consider them to be relevant, they would have to firstly consider all of the sources to determine what is and is not relevant. I believe this would risk placing a disproportionate burden on both litigants and the courts, and as such could delay children and young people achieving effective remedies for breaches of their rights. The changes to Section 4 would also risk the sources included in Section 4 being interpreted in a way which is not intended. These sources are widely understood to be authoritative sources of interpretation, but they are not legally binding. Since Stage 2, the Scottish Government has continued to work closely with key stakeholders, including the Commissioner for Children and Young People in Scotland, and together to better understand what they were seeking to achieve and to explore how best to do this. Hence, we have brought forward a range of amendments which we understand carry stakeholder support that seek to restore but also to improve the approach in Section 4 and elsewhere. Amendment 3 therefore restores the original drafting in Section 4.1 to avoid the unintended consequences that I have just set out, allowing courts to retain discretion in relation to whether any sources should be taken into account in cases which come before them. Since Stage 2, key stakeholders, including the Children's Commissioner and Together, have expressed interest in the sources included in Section 4.2 being expanded further. We are clear that the UNCRC requirements should be interpreted in their full international context, but it is important that we provide for this in a way which is not exclusive or prescriptive and does not prevent those sources being added to in the future. Amendments 4 and 5 seek to achieve this. Amendment 4 removes the new Section 4.2g, and Amendment 5 removes the detailed list at Section 4.5, with Amendment 4 also replacing Section 4.2g with a much broader provision to include other international and comparative law. This will ensure that it is clear on the face of the bill that there is a rich tapestry of global human rights instruments and law which can assist courts, practitioners and public authorities in the interpretation and implementation of children's rights under the UNCRC, whether this is from the United Nations, the Council of Europe or other jurisdictions. I am delighted that the recommendations of the National Task Force on Human Rights Leadership were published on Friday. This Parliament will have the opportunity to consider how best to deliver a human rights framework for all after the forthcoming elections. I believe that our work on this bill provides a strong foundation for that work and recognises the intersectionality of human rights. It will be important that children's rights under this bill are considered within the context of wider international human rights obligations, such as under the Convention on the Elimination of All Forms of Discrimination Against Women and the Convention on the Rights of Persons with Disabilities, which have a direct impact on the fulfilment of children's rights under the UNCRC. Amendments 4 and 5 will ensure that this wider international context and intersectionality is provided for based on current relevant conventions and potential future conventions to come. As amended at Stage 2, Sections 12 and 13 place requirements on Scottish ministers to publish a child rights scheme and to review the scheme and its operation each year. It is intended that these mechanisms will afford transparency and accountability to the steps taken or which are planned by ministers in relation to the compatibility duty in Section 6 and steps taken to give better and further effect to the rights of children. Amendments 16 to 19, 23 and 24 therefore provide for consideration of relevant international or comparative law in relation to Sections 12 and 13, creating a consistent approach with Section 4. They will ensure that the sources added to Section 4 by Amendment 4 are considered by Scottish ministers when they make, amend or report on the child rights scheme. Presiding Officer, I welcome that committee members encouraged us to take a closer look at our approach on these key matters, particularly in relation to intersectionality of rights, laws and conventions. I hope that what these amendments would put in place gives members confidence that we have the right approach and that they will support all of the amendments in Group 2. I move Amendment 3.
Thank you very much, Cabinet Secretary. Can I call Jamie Green?
Thank you, Presiding Officer. I'd like to speak briefly to this set of amendments. These are effectively reversing some of the changes to the bill that were made at stage 2 by the committee, decisions made by majority on the committee. And I'm not entirely convinced the case has been made for their removal. Amendment 3, for example, it may seem like a small change from must to may, but the effect of doing so effectively weakens, in our view, the reach of the bill in allowing courts the flexibility needed to consider every aspect of the UNCRC in related texts. So if the UNCRC is to be incorporated into Scottish law as fully as possible, then it is only right that the courts must consider both this and any related texts. And this is the key, so far it is relevant to the interpretation of the UNCRC, which I think therein lies the get-out, that it is, in the court's opinions, their subjectivity as to which subsection 2 issues they must take into account. Amendments 4 and 5 also, I think, seek to undo improvements that were made to the bill at stage 2. These amendments would remove the explicit references to the UN Treaty, general comments, concluding observations and comparative law, which we feel the inclusion of which strengthens this section of the bill by ensuring the courts adopt a comprehensive approach in its interpretation of its UNCRC requirements. The Cabinet Secretary just made mention of wanting to have a rich tapestry of sources available. You do not get a rich tapestry by removing things off the face of the bill in the manner in which is suggested. So we will be voting against all amendments in this group.
Thank you. Does the Cabinet Secretary wish to add anything by way of winding up?
So let me briefly address the issues that Jamie Green has raised, and he cited particularly the provisions in relation to Amendment 3. I don't accept the interpretation he's applying to that particular change, because what we're trying to do here is to recognise the importance of the courts being able to take the widest possible view on the information that and sources of interpretation that enable the courts to consider any particular issues that are presented to them. So we are trying to take the most open approach possible to enable the courts to be able to exercise the widest possible scope, and therefore, as a consequence, to be able to take into account the broadest range of factors in determining what would be appropriate sources of interpretation. And that's the basis upon which the government is advancing the amendments today. The general point I would make in relation to the grouping also is that we're specifically expanding the range of sources that can be included to include other international law and comparative law, therefore demonstrating how further steps have been taken to expand sources. And I hope that provides the necessary reassurance to Parliament of the intentions that the government has in this particular section to enable the broadest perspective to be undertaken in the interpretation of the requirements of the Convention. Thank you, President Officer.
Thank you, Cabinet Secretary. So, moving to the question. The question is that Amendment 3 be agreed to. Are we agreed? Yes. We're not agreed. This is the first division of the afternoon, so I'm going to suspend for 5 minutes just to call members to the chamber and to allow members online to access the voting app. Parliament is suspended for 5 minutes. Thank you. So we're now back in session and we're going to go straight to the vote. The vote is on Amendment 3 in the name of the Cabinet Secretary John Swinney. Members may cast their votes now. This is a 1-minute division on Amendment 3 in the name of the Cabinet Secretary John Swinney. That vote is now closed. Please let me know if you were not able to vote. Thank you. The result of the vote on amendment number 3, amendment number 3 in the name of John Swinney is yes 85, no 25. There were no abstentions. The amendment is therefore agreed. Can I call amendment 4, John Swinney, to move?
Move, Presiding Officer.
Thank you. The question is that amendment 4 be agreed to. Are we all agreed? Yes. We're not agreed. We move to a division on amendment 4. This will be a 1-minute division. 1-minute division, amendment 4 in the name of the Cabinet Secretary. That vote is closed. Please let me know if you are not able to vote. The result of the vote on Amendment 4 in the name of John Swinney is yes 86, no 25. There were no abstentions. The amendment is therefore agreed. Can I call Amendment 5 in the name of the Cabinet Secretary? Cabinet Secretary to move?
Move, Presiding Officer.
Thank you. The question is that Amendment 5 be agreed to. Are we agreed? Yes. We're not agreed. We'll move to a vote on Amendment 5, a 1-minute division. Thank you. 1-minute vote on Amendment 5. That vote is now closed. The result of the vote on Amendment 5 in the name of John Swinney is yes 83, no 26. There were no abstentions. The amendment is therefore agreed. I'm going to turn now to Group 3. This is on the meaning of public authorities. Can I call Amendment 6 in the name of the Cabinet Secretary, grouped with Amendments 7, 8 and 9, and Minister Marie Todd to move Amendment 6 and speak to all the amendments in this group?
Presiding Officer, Section 6 is critical to the bill. It contains the central compatibility duty, which will require to the fullest extent possible within the Parliament's powers that public authorities do not act incompatibly with the UNCRC requirements set out in the schedule. Section 6 therefore needs to be as strong and as accurate as it can be. The definition of a public authority in Section 6(1) of the bill is intentionally wide and will include the full range of public authorities it is possible to cover. Section 6(3) provides that this includes in particular the Scottish Ministers, a court or tribunal, and any person certain of whose functions are functions of a public nature. Again, this final element is intentionally wide and is intended to capture the wide variety of public functions which are and may be in the future undertaken by those other than core public authorities. I understand why Mary Fee sought to include the further provision at Section 6(3)(a)(1)(v) and what her intent might have been behind it. We all want to be crystal clear and for there to be no dubiety that all public bodies who have functions in relation to the care of children should be included in the definition of a public authority in this bill. And I hope I can assure Mary Fee and other members that those functions were already captured by the wording of Section 6 prior to this amendment and will continue to be captured without this provision on the face of the bill. Far from achieving this effect, the provision potentially has the opposite effect in that it may suggest that other functions which are not specifically named are not included and create uncertainty about the otherwise wide application of the definition of a public authority in Section 6. It is for this reason that I have lodged Amendment 7, and I hope members will understand the reasons why and support the amendment. There are also potentially unintended consequences behind paragraph B of Section 6(3)(a). It risks unintentionally narrowing the scope of paragraph A of Section 6(3)(a) and therefore the compatibility duty more broadly. But again, I understand the intent behind it. I've been clear that it is the Scottish Government's intention that the requirement not to act incompatibly with the UNCRC requirements should extend to others where they are carrying out functions under contracts or other arrangements with public authorities. That is the effect of Section 6(3)(a). I do not believe that this should be subject to the further qualification in Section 6(3)(a)(b), that the core purpose is the provision of a service which fulfills children's rights. I believe this could introduce confusion in relation to the scope of the UNCRC requirements in contracting out arrangements, which is not intended. So Amendment 8 seeks to remove this provision and replace part of it with the wording in Amendment 9. Section 6 is broadly modelled on the equivalent provision in Section 6 of the Human Rights Act 1998. However, the bill, as amended at Stage 2, seeks to go further than its Human Rights Act equivalent by making additional provision in Section 6(3)(a) in relation to contracting out arrangements. This reflects the fact that in Scotland, for some years now, public services have been provided by a wide range of core and hybrid public authorities, third sector bodies and private providers. There's concern amongst stakeholders that the court's interpretation of what constitutes a function of a public nature under the Human Rights Act has become overly narrow. This is a concern I have sympathy with, and it is why the Scottish Government brought forward an amendment at Stage 2, which is now Section 6(3)(a), to make it clear that functions carried out under a contract or other arrangement with a public authority fall within the scope of the compatibility duty in Section 6. What Amendment 9 seeks to do is provide certainty that how a function is funded should not be determinative of its classification as a function of a public nature. The other government amendment in this group, Amendment 6, is a minor amendment to improve the wording of Section 6. Presiding Officer, I hope that members accept these amendments, that these amendments seek to be helpful in applying greater clarity and certainty to this vital duty, and will support them. I move Amendment 6.
Thank you very much, Minister. Can I call Jamie Green?
Thank you, Presiding Officer. Can I thank the Minister for clarification on some of those amendments, specifically 6A to 9. I think they're very helpful changes at stage 3. However, Amendment 7 is probably the one that we still remain to have difficulties with. The Minister seems to imply that the... let's take a look at what this actually is doing, this amendment. It says that it is unlawful for a public authority to act in a way which is incompatible with the UNCRC. Public authority means, and in the section of the clause that the government is removing, all public bodies who have functions in relation to the care of a child. Now, the argument has been made that the inclusion of this at stage 2 somehow is a restrictive clause, not an inclusive one, it is argued. The government also argues that it somehow narrows the definition of a public body. We would argue that it widens it and makes it inclusive. Now, I would say perhaps all public bodies would have been better phrased as any, but it is what it is at stage 2. That amendment was passed by the committee, and we believe it should still remain. I'm not entirely convinced that the case has been made for its removal, because surely all public bodies who have functions in relation to the care of a child should be encompassed by the very essence of the bill, given this is, as was stated, this is one of the most important sections of the bill. So perhaps in summing up, the Minister can explain why technically removal of all public bodies who have functions in relation to the care of a child is necessary.
Thank you. And I call on the Minister to wind up in this section.
Thank you, Presiding Officer, and I'm grateful for your support on some of the amendments. The bill, Section 6 of the bill really needs to be as strong and as accurate as it can be. Amendments 7 and 8 address the concern that the latest provision suggests that functions which are not specifically named are not covered by the duty not to act incompatibly. And the concern is that the specific provision which in relation to the care of children undermines the general application of the compatibility duty to all functions of public authorities. It introduces the idea that children's rights are only relevant in certain children's services, which is not desirable at all.
Jamie Green.
Again, the tone of that is that this somehow restricts the application of the bill. It actually says, and this is what the government is trying to remove, all public bodies who have functions in relation to the care of the child. There's nothing restrictive about that whatsoever.
Minister Marie Todd.
Thank you. It is by definition restrictive because it says have function in relation to children. What we are trying to do is produce a bill which has introduces compatibility duties on all public authorities, and that the idea that children's rights are relevant in every sphere of the public society. An example I would give is in the digital environment. There's arguments put forward that children don't need to be protected in digital areas which aren't targeted at children. I would argue that children need to be protected entirely in the digital environment, that it shouldn't just, the compatibility requirement shouldn't just be targeted at those areas which are specifically directed at children. It needs to be broader than that. Children are everywhere. So that is why we are concerned about the restrictive nature of this amendment, and that is why we are keen to remove what we perceive to be an unintended restriction on that point. It also introduces the term public bodies, which isn't used elsewhere in the bill, so it introduces a complexity on that front. To guard against a narrow interpretation of what constitutes a function of a public nature, Amendment 9 provides certainty that how a function is funded shouldn't be determinative of its classification as a function of a public nature. And again, I'd be grateful for the Chamber's support on that front. Thank you.
Thank you very much. So we're going to move to the vote. The question is, the Amendment 6 be agreed to? Are we all agreed? Yes. We are agreed. Can I call Amendment 7, Minister, to move?
Moved.
Thank you. The question is that Amendment 7 be agreed to. Are we agreed? Yes. We're not agreed. We're going to move to a division on Amendment 7. This will be a 1-minute division. Amendment 7, in the name of the Cabinet Secretary, a 1-minute division. Thank you. That vote is closed. Please let me know if you were not able to vote. The result of the vote on Amendment 7 in the name of John Swinney is yes 84, no 25. There were no abstentions. The amendment is therefore agreed. Can I call Amendment 8 in the name of John Swinney? Minister to move. Thank you. The question is that Amendment 8 be agreed to. Are we all agreed? Yes. We are agreed. Can I call Amendment 9 in the name of John Swinney? The Minister to move. Or Cabinet Secretary to move. Thank you. The question is that Amendment 9 be agreed to. Are we all agreed? Yes. We are agreed. Thank you. We're going to turn now to Group 4. This is on regulations under Section 7. Can I call Amendment 10 in the name of the Cabinet Secretary, grouped with Amendments 11, 12, 13 and 37. Cabinet Secretary John Swinney to move Amendment 10 and speak to all the amendments in this group.
Presiding Officer, Section 7 of the Bill makes provision about proceedings in relation to acts of public authorities which are incompatible with the UNCRC requirements. As amended at Stage 2, Subsection 5 places a duty on ministers to do certain things by regulations in relation to remedies for tribunals. These include adding to the relief or remedies that a particular tribunal can grant, the grounds on which they can be granted and the orders which the tribunal may make. The duty on ministers applies where they consider the regulations are necessary to ensure that the tribunal can provide appropriate remedies for breaches of the compatibility duty in the bill. This is intended to ensure that where a tribunal does not have the power to provide an appropriate remedy for a breach of the compatibility duty, the Scottish ministers can take steps to provide for this quickly without having to resort to primary legislation. As the Minister set out in Stage 2, the Section 7.5 power is subject to parliamentary scrutiny through the affirmative procedure and to reflect the fact that the making of regulations under Section 7.5 cannot be guaranteed by the Scottish ministers. Amendments 10 to 13 adjust this provision so that the duty on ministers is instead to lay draft regulations before the Parliament in the circumstances set out in Section 7.5. These technical amendments seek to provide absolute clarity and accuracy on the face of the bill about the purpose and the effect of these added provisions. I move Amendment 10, Presiding Officer.
Thank you very much. Can I call Ruth Maguire to speak to Amendment 37 and the other amendments in the group?
Presiding Officer, Section 7.5 of the Bill requires that Scottish ministers must, in certain circumstances, lay regulations to add to the remedies which a particular tribunal can award. The requirement will apply where the Scottish ministers consider it necessary to ensure that the tribunal can award an appropriate remedy where a public authority has acted incompatibly with the UNCRC requirements. Amendments were made at Stage 2 requiring the Scottish ministers to consult such persons as they consider appropriate when making such regulations. Amendment 37 seeks to apply greater clarity and consistency on whom should be consulted and will further provide at Section 5A that specific consultation is required with the Commissioner for Children and Young People in Scotland and the Scottish Commission for Human Rights, in line with other consultation requirements in the bill. I welcome Scottish Government's support for this amendment and move it in my name.
Thank you very much. I have no other indications members wish to speak. Does the Cabinet Secretary wish to add anything by way of winding up?
Presiding Officer, can I simply place on the record that the Government fully supports Ruth Maguire's amendment, which will place the same consultation requirements on the use of this power that are included elsewhere in the bill, and I would urge members to support Amendments 10 and 37.
Thank you very much, Cabinet Secretary. So the question is that Amendment 10 be agreed to. Are we all agreed? Yes. We are agreed. Can I call Amendments 11, 12 and 13 all in the name of the Cabinet Secretary and invite the Cabinet Secretary to move them en bloc?
Moved en bloc, President.
Thank you. Does any member object to a single question being put on Amendments 11 to 13? No. No, that's good. So the question is that Amendments 11 to 13 are agreed to. Are we all agreed? Yes. We are agreed. Thank you. Can I call Amendment 37 in the name of Ruth Maguire? Ruth Maguire to move?
Moved.
Thank you. The question is that Amendment 37 be agreed to. Are we agreed? Yes. We are agreed. Turning now to Group 5. This is on guidance on Part 2. Can I call Amendment 38 in the name of Mary Fee in a group on its own? Mary Fee to move and speak to Amendment 38.
Thank you, Presiding Officer. The issue of guidance has been of interest to many stakeholders throughout the consideration of this bill and to many members across this chamber. And that's what prompted me to lay my amendments in relation to this at stage 2. But I was also happy to listen to the Minister and not press those amendments. And as with so much else in this bill, it has been proceeded in a spirit of cooperation and consensus. And I am pleased that we have been able to do so when making the provision of guidance statutory. And I acknowledge and welcome that the Scottish Government always intended to prepare and publish guidance. But I do think that it's important that this commitment is made a requirement and that it is clear through the bill itself that guidance will be made available in support of effective implementation. And that's what Amendment 38 will deliver. It will ensure that ministers are required to issue guidance in support of Part 2 of the bill and that there is wide consultation, including with children and young people, about what is contained within that guidance. And whilst guidance will not replace the responsibility which public authorities will all have to ensure that their actions are compatible with children's rights, this amendment will strengthen the bill and ensure that public authorities are supported to fulfil the rights of children and young people. And I hope that members across the chamber can agree with me and support Amendment 38, which I move. Thank you.
Thank you very much. And I call on the Minister, Marie Todd, to respond.
Presiding Officer, I thank Mary Fee for not pressing her amendments in relation to guidance at stage 2 and allowing us the time to discuss with her and stakeholders. It has always been the intention of the Scottish Government that a range of guidance and materials will be developed in partnership to support effective implementation of children's rights. This is, after all, groundbreaking legislation, and there will be a lot to think about in terms of how we best go about implementing its duties. Authorities and individuals will rightly need help and support in that, and officials are already engaging closely with public bodies and other key stakeholders to ensure they are supported to realise children's rights in practice. That will be fundamental to this bill's success. However, as I said at stage 2, government guidance cannot and should not replace the responsibility which will rest on all public authorities to ensure that they comply with their duty under Section 6. Guidance is not a substitute for considering the rights of children in all circumstances or for public authorities being proactive in their consideration of what this means to the delivery of their services to children and young people. Only through a proactive culture of everyday accountability for children's rights across public services can we ensure that children's rights are fully protected, respected and fulfilled. Presiding Officer, I thank Mary Fee for her cooperation and welcome her Amendment 38 to require the Scottish Ministers to issue guidance to support the implementation and operation of Part 2 of the bill.
Thank you very much. And does Mary Fee wish to add anything by way of winding up?
No, thank you, Presiding Officer.
Thank you very much. So we'll move straight to the vote. The question is that Amendment 38 be agreed to. Are we all agreed? Yes. We are agreed. Turning now to Group 6. This is on Children's Rights Scheme. Can I call Amendment 14 in the name of the Cabinet Secretary, grouped with amendments as shown in the groupings? Minister Marie Todd to move Amendment 14 and speak to all amendments in this group.
Presiding Officer, the Children's Rights Scheme, which is provided for in Section 11 of the bill, is a crucial and fundamental mechanism to promote and deliver the aims and ambitions which underpin this legislation to proactively change the culture in Scotland. I welcome the significant and positive engagement from members and stakeholders with the scheme's provisions throughout the bill process. We all want to see the scheme strengthened where possible, particularly in relation to the list of matters included in Section 11.3. In relation to the government amendments in this group, Amendment 14 strengthens Section 11.3a of the bill and recognises the important role which children's advocacy services can play in ensuring children are able to participate in the making of decisions that affect them. If we want children to to participate in making decisions that affect them, we must recognise that they require support to do so, particularly where they have additional support needs or face challenges or barriers to knowing their rights. This amendment strengthens the scheme in this respect. Amendment 15 will ensure that there is additional transparency in relation to the protection of children's rights in private settings. The bill ensures that there is direct accountability through the compatibility duty in Section 6 in relation to all public functions. This reflects the fact that the UNCRC, like other international human rights treaties, places obligations on states to ensure that rights are respected, protected and fulfilled. The compatibility duty in Section 6 will mean that ministers will be required to take all measures required by the UNCRC requirements, which could include legislative measures to ensure that children's rights are protected in private settings. Amendment 15 adds to this by seeking to provide transparency in relation to this dimension of the duty on ministers and in relation to steps taken by ministers to give better and further effect to the rights of children in private settings. In implementing this requirement through the Children's Rights Scheme, the Scottish Government will consider best practice globally and will be guided by, amongst other things, the UN Guiding Principles on Business and Human Rights. Amendments 20 and 21 are technical and I hope their purpose is clear. They ensure consistency between Section 11.1 as amended at Stage 2 and Section 13.3 and will require that reports about the scheme under Section 13.3 in relation to the Children's Rights Scheme must also include a summary of the actions taken by the Scottish Ministers for securing better or further effect of the rights of children in the reporting period. Amendment 22 is a minor technical amendment which improves the wording of Section 13.3. In relation to Amendment 39, the Scottish Government supported the inclusion of Section 11.3AA in the bill at Stage 2 and we're happy to support Amendment 39, which seeks to provide the further clarity that Together and the Children's Commissioner are seeking, not least through the annual scrutiny and associated reporting requirements for the scheme. We can all agree that we should all be doing everything that we can to identify and address the needs of children who are most at risk of their rights being unfulfilled. Scottish ministers are also supportive of Amendment 40 and I want to pay tribute to all that Mark Griffin has done in this Parliament and the last to promote the communication support needs of children and young people. Scottish ministers will be happy to help give effect to this amendment in practice by ensuring that information on how to communicate inclusively with children and young people will be included in all relevant guidance issued in support of the bill, and we will of course involve key stakeholders in that work. Presiding Officer, I move Amendment 14 and encourage members to support all the amendments in this group.
Thank you very much, Minister. Can I call Joe Fitzpatrick to speak to Amendment 39 and the other amendments in the group? Joe Fitzpatrick.
Thank you, Presiding Officer. Presiding Officer, I think we all agreed with the intention of the Stage 2 amendment, which passed on this issue, if not the execution. As drafted, it doesn't quite achieve what it set out to do. Amendment 39 therefore seeks to ensure that there is good transparency and accountability through the Children's Rights Scheme for the steps taken by Scottish ministers to identify and address the needs of children who are most at risk of their rights being unfulfilled. In order to ensure that children's rights are realised for all children and young people, it's essential that scrutiny in relation to the barriers faced by those whose rights are most at risk of being unfulfilled is prioritised. This amendment has been developed through close working with members of Together. They've said that this amendment is about making sure that we understand and recognise the risk issues facing children and young people from specific population groups. This will include children and young people with learning disabilities, experienced children and young people, and children and young people who are impacted by parental imprisonment. Ensuring the experience of these children and young people are reflected in the Children's Rights Scheme is critical. These children face considerable barriers in accessing their human rights, and we can see evidence of this when we think about the experience and life opportunities of children and young people with learning disabilities. For example, recent findings from the Scottish Learning Disabilities Observatory showed that premature mortality was 12 times higher for children and young people with learning disabilities. than the rest of the population. This is simply unacceptable. This amendment is therefore important because it will ensure that there will be a focus to the Children's Rights Scheme on the barriers faced by those children and young people whose rights are most at risk, and on the steps which ministers plan to take to address this. While this was the intention of the Stage 2 amendment, its drafting didn't quite achieve that. So that's why these amendments correct. Amendment 41 is a technical amendment with the purpose of removing a redundant definition. And what's been said by the Minister in relation to Amendment 14 and fully support it. The provision of advocacy or some other support services will be critical for some children to be able to participate in decisions that are made about them. And on a similar vein, I also support Mark Griffin's Amendment 40, which will ensure that children with most complex support needs are able to receive inclusive communication. I don't think we should underestimate the difference having statutory duties and requirements like this in place will make for some children. Also happy to support the amendments in this group.
Thank you, Mr Fitzpatrick. Slightly bad line, but I think most members will be able to follow that. Can I call Mark Griffin to speak to Amendment 40 and the other amendments in this group?
Thank you, Presiding Officer. We'll be supporting all amendments in this group. Amendment number 40 in my name is sponsored by the Alliance of Health and Social Care and Deaf Scotland, as well as Together. And I'm very grateful for the discussions we've had with Government and have the support of ministers today. Members will be aware that other inclusive communication amendments have been included in other bills, the Social Security Act, Consumer Scotland Act and the Coronavirus No. 2 Act. Each placed duties on the Scottish Government to use the inclusive communication whilst exercising their functions under those acts. Though inclusive communication is required directly and indirectly in the UNCRC, this further duty to use and promote inclusive communication will realise the Convention objectives and ties in with the Articles 2, 12, 13, 17 and 29. But because this UNCRC bill works differently, so too does this amendment. This amendment therefore makes explicit provision for inclusive communication in the bill through the requirements of the Children's Rights Scheme. Communicating in a way that is inclusive with all people, particularly those who have a disability or specific communication needs, means that information can be better received, understood and accepted by the widest audience. Doing so recognises that people understand information and express themselves in different ways. Presiding Officer, though there has been some discussion about a wider inclusive communication bill in itself to put that principle into Scots law, I hope members can support Amendment 40 to secure its inclusion in this important piece of legislation. Thank you.
Thank you very much, Mr Griffin. Can I call Jamie Green to be followed by Alex Cole-Hamilton?
Thank you, Presiding Officer. We welcome the Children's Rights Scheme included in this bill. I just want to speak against Amendments 39 and 41, 41 being a technical consequential 39. This effectively is about an amendment that was added at stage 2, and it reads that the scheme must ensure that children who have one or more protected characteristics or in a situation of vulnerability have their rights respected, protected and fulfilled. I find it hard to disagree with any of that. Mr Fitzpatrick, although it was quite difficult to hear his argument, said, I believe, that as drafted it doesn't achieve what it sets out to do, but I think failed to make the case as to why, as it's drafted, it fails to set out what he wants to do. His Amendment 39 removes those two lines and inserts wording which I actually find it hard to disagree with. It does beg the question, though, why the wording suggested by Mr Fitzpatrick replaces rather than adds to what is already in the bill at stage 2. If it was simply adding the wording as he recommended, we would be minded to support it, but it doesn't, it replaces, therefore we won't and can't.
Thank you very much. And Alex Cole-Hamilton.
Thank you very much, Presiding Officer. I wish to speak in favour of all amendments in this group, but particularly Amendment 40 in the name of Mark Griffin. I think it speaks to Mark's contribution in this chamber over the years in terms of his dedication towards speech and language, that he has submitted this. This speaks to the values of the Act that we are passing, and in particular Article 12, which is about hearing the voice of the child. Communication is still a problem in Scotland. listening to, seeking out the views of and understanding the views of the people that we are doing things to and around has always been a problem. And the UN Convention on the Rights of People with Disabilities rapporteur often comes back and says that we should be doing more, particularly around mental welfare, to get the views of the people that we're trying to assist. So I absolutely support Mark's amendments. The Liberal Democrats will support all the amendments in this group.
Thank you very much. And can I call on the Minister Marito to wind up in this group?
Thank you, Presiding Officer. I think Amendment 14 strengthens the Children's Rights Scheme, and it recognises the important role which children's advocacy services can play in ensuring children are able to participate in the making of decisions that affect them. Amendment 15 requires ministers to set out the steps that they have taken to give better and further effect to the rights of children in private settings, and I'm grateful for all parties' support on those amendments. Amendments 39 and 41, children whose rights are at risk of not being fulfilled, is one which concerns children with protected characteristics and in situations of vulnerability. That's the wording that was passed at stage 2. We think that wording has certain feelings and challenges, and we think that we support the intent of that wording, and we are keen to amend it. And Amendment 39 just simply seeks to achieve a better wording for the same intent and has the support of key stakeholders and Mary Fee, who pressed that amendment at stage 2. So I'd be grateful for members' support for that amendment too. Thank you.
Thank you very much, Minister. So we move to the question on Amendment 14. The question is that Amendment 14 be agreed to. Are we all agreed? Yes. We are agreed. Can I call Amendment 39, Joe Fitzpatrick, to move?
Moved.
Thank you, Mr Fitzpatrick. The question is that Amendment 39 be agreed to. Are we agreed? Yes. We're not agreed. We'll move to a division on Amendment 39. This is a 1-minute division. Amendment 39 in the name of Joe Fitzpatrick. That vote is now closed. Please let me know if you were not able to vote. Can I call Linda Fabiani to make a point of order?
And it wouldn't work. I would have voted yes.
Thank you, Ms Fabiani. You would have voted yes. I'll make sure your vote is noted. Thank you. So I've got... Point of order, Bob Doris first. Bob Doris.
Thank you, Presiding Officer. I was unable to vote on Amendment 39. I would have voted yes.
So you would have voted yes, Mr Doris. Thank you. Point of order, Bill Kidd at the back.
Order, please. Thank you. I would have voted yes. I had a problem with my voting.
Thank you, Mr Kidd. You would have voted yes. That will be added to. The result of the vote on amendment number 39 in the name of Joe Fitzpatrick is yes 87, no 24. There are no abstentions. The amendment is therefore agreed. Can I call amendment 15? This is the name of the Cabinet Secretary. Minister to move. Thank you. The question is that amendment 15 be agreed to. Are we agreed?
Yes.
We are agreed. Can I call amendment 40? Mark Griffin to move.
Moved, Presiding Officer.
Thank you. The question is that Amendment 40 be agreed to. Are we all agreed? Yes. We are agreed. Can I call Amendment 41, Joe Fitzpatrick, to move?
Moved.
Thank you very much. The question is that Amendment 41 be agreed to. Are we all agreed? Yes. We're not agreed. We'll move to a division on Amendment 41. Members, be cast their votes now. Amendment 41 in the name of Joe Fitzpatrick. That vote is closed. The result of the vote on amendment number 41 in the name of Joe Fitzpatrick is yes 86, no 24. There were no abstentions. The amendment is therefore agreed. I'm now going to call amendments 16 to 24. These are all in the name of the Cabinet Secretary and they were all debated previously either in Group 2 or Group 6. Can I invite the Cabinet Secretary to move on block?
Moved on block, President.
Thank you. Does any member object to a single question being put on amendments 16 to 24? No. In that case, the question is that amendments 16 to 24 are agreed to. Are we all agreed? Yes. We are agreed. Thank you. Turning now to Group 7. This is on impact assessments. Can I call Amendment 42 in the name of Fulton McGregor? This is grouped with Amendment 25, 26, 27, 28 and 29. Fulton McGregor to move Amendment 42 and speak to all the amendments in this group.
Thank you, Presiding Officer. It's a huge honour to move and speak to my Amendment 42 today during this historic moment for our Parliament and for our children and young people. I welcome Section 14(3)A and 3(b), which were included at Stage 2, and will require that Scottish Ministers have to prepare a child rights and wellbeing impact assessment in relation to decisions to restrict the delivery of in-person education to children. The COVID-19 pandemic has brought previously unimaginable restrictions on our everyday lives, and of course this has included the closure of schools for 2 separate significant periods of time. While necessary for public health, we cannot underestimate the potential short and longer term impact on our young people, and this is especially true when we're talking about children's rights. I know and welcome that the rights of children and young people are at the heart of the decisions which the Scottish Government has taken and continues to take in relation to managing the impact of coronavirus on children and young people. And I think this is evident in the prioritisation of in-person learning as we move out of restrictions, a prioritisation that I, and I know many others, are very grateful for. I also welcome that when children's rights and wellbeing impact assessments are required to be prepared in relation to Section 14 provisions more generally, they must be published by the Scottish Government. It makes sense, therefore, to provide for their publication under this provision. Amendment 42, therefore, seeks to achieve this and will ensure that Section 14(3)A is in line with the rest of Section 14, so that in addition to preparing such impact assessments, Ministers must also publish them. I move Amendment 42, Presiding Officer, and support the other amendments in the name of the Cabinet Secretary in the group.
Thank you very much, Mr McGregor. And can I invite the Cabinet Secretary to speak to Amendment 25 and the other amendments in this group? John Swinney.
Presiding Officer, as the Minister set out during Stage 2, Ministers are supportive of a provision to require Ministers to prepare child rights and wellbeing impact assessments in relation to decisions about school closures in the context of the COVID pandemic. The amendments which are lodged today are intended to make the provision work more effectively. Amendments 25 and 27 make it clear that the duty imposed on ministers to prepare this category of child's rights and wellbeing impact assessments applies only in relation to decisions taken by ministers and strategies prepared by ministers. I am concerned that the references to school age in these provisions may be taken to mean that decisions affecting the in-person education of pupils above school age would not be within the scope of the provision. This would have the effect of excluding decisions affecting 16 and 17-year-olds from coverage. I do not imagine that this was the intended effect of the provision. Therefore, Amendments 26 and 28 make the scope of the provision clearer so that it covers all children at school. I support Fulton McGregor's Amendment 42, which builds in the requirement to publish and not just prepare this category of child rights and wellbeing impact assessments. So, President Officer, I move Amendment 25 and urge members to support it, along with Amendments 26 to 29 and also Mr McGregor's Amendment 42.
Thank you very much, Cabinet Secretary. Mr McGregor, is there anything you wish to add by way of winding up in this group?
Thanks, President Officer. Nothing further to add, just to press my amendment.
Thank you very much. So we'll move to the vote. The question is that Amendment 42 be agreed to. Are we all agreed? Yes. We are agreed. Thank you. Can I call Amendments 25 to 29 and invite the Cabinet Secretary to move en bloc?
Moved en bloc, President Officer.
Thank you. Does any member object if we put a single question on Amendments 25 to 29? No. No. In that case, the question is that Amendments 25 to 29 are agreed to. Are we all agreed? Yes. We are agreed. Thank you. Turning now to Group 8. This is on listed authorities, their functions and reporting arrangements. Can I call Amendment 43 in the name of Claire Adamson, grouped with Amendments 44, 30 and 45. Claire Adamson to move Amendment 43 and speak to all the amendments in this group.
Thank you very much, Presiding Officer. Section 15 of the bill requires listed authorities to report on the actions they have taken to meet the UNCRC requirements and on what steps they have taken more widely towards the progressive realisation of children's rights. In order to drive the proactive culture change that we all want, it will be important that these reports are acted upon as quickly as possible. Whilst listed authorities will of course be responsible for taking the actions identified in the reports, it will also be important that ministers are aware of these reports and their contents. Amendments 43 and 44 will ensure that the reports from listed authorities are shared with Scottish ministers as soon as is practicable after they are published, so that the Scottish Government is aware of their contents. I believe that this will further support the proactive realisation of children's rights in the bill that the bill promotes. I understand that there are some issues with revisions under the 2014 Children and Young People Act, an act that I was a committee member of as it went through the Parliament, and with similar reporting duties in its listed authorities without a corresponding duty to send a copy to ministers. It would seem plainly obvious to me that it would be in everyone's interest for this to happen as a matter of course. I'm not quite sure why it doesn't, but providing for it to happen in statute makes it clear what is expected of listed authorities. I move Amendment 43. I'm keen to listen to hear Mary Fee's arguments in support of Amendment 45, and if I possibly can pause a moment, Presiding Officer, to commend Mary Fee for her commitment to children's rights, but also to the rights of meeting workers, and particularly Gypsy travellers over her time in this Parliament. I wish her well for ongoing endeavours. It is worth noting that it will not be the first or indeed the last time the Parliament has come together to provide a statutory underpinning to guide and provided direction on how guidelines should be drafted and developed. I'm likely to be happy to support Mary Fee's amendment as well, and the Government's, which I think are an essential tidy up of amendments, but important ones that apply. Thank you, Presiding Officer.
Thank you very much, Ms Adamson. And just for information, we were struggling to hear you there, just at the edge of audibility, so maybe we could adjust the volume for winding up, if you wish to add anything. Can I call the Minister to speak to Amendment 30 and the other amendments in this group? Marie Todd.
Presiding Officer, Section 15 was amended at stage 2 to provide that listed authorities under the reporting duty in Section 15 are not only required to report on what actions they've taken to meet the minimum standards in the UNCRC requirements, but also what steps they have taken more widely towards the progressive realisation of children's rights. Section 15 of the bill requires listed authorities to prepare and publish reports every 3 years on what they've done to comply with the duty in Section 6(1) of the bill, and also the actions they have taken to secure better or further effect of the rights of children. Listed authorities will also be required to set out and report on their plans for the next 3-year period. I welcome and support Amendments 43 and 44, which clarify the reporting cycle for these reports and ensure the published reports will be shared with Scottish ministers. It is a small but important addition that will help create synergy and accountability across all relevant authorities. As I set out at stage 2, the Scottish ministers will be required to report annually on the operation of children's rights schemes. These reports will set out a number of things, including the steps that ministers are taking and plans they have to comply with the duty in Section 6. The reports will also set out ministers' plans for giving better and further effect to the rights of children. The requirement to prepare and publish these reports annually will relate to all of the Scottish Ministers' functions, including those of executive agencies such as the Scottish Prison Service. As such, Section 16(1)(ka), which includes the functions of the Scottish Prison Service in the listed authorities required to report under Section 16, is unnecessary. It's also at odds with the requirement on ministers to report annually under Section 13. Under Section 16, listed authorities are only required to report every 3 years. But we understand fully the motivation behind it, which is to try to seek to ensure that in future the impact of imprisonment on children and a child's rights is addressed. They are one of the most vulnerable groups of children in our society, and while the prison service and organisations like Families Outside have made significant progress in this regard in recent years, there is more to do to make sure that the rights of children affected by imprisonment can be fully and most effectively realised. We will therefore set out in the explanatory notes that the effect of the bill is that functions of executive agencies, including the Scottish Prison Service, will be covered by the Children's Rights Scheme and the annual reports on the scheme. I have written to Families Outside who supported the inclusion of this provision at stage 2, and I'm pleased that they have confirmed they are content with its removal and our suggested alternative approach. I also welcome and support Amendment 45. As I said earlier in support of Amendment 38, it has always been the intention of the Scottish Government that a range of guidance and materials will be developed in partnership to support effective implementation of children's rights and the reporting duties under Section 15. Amendment 45 rightly sets out how that guidance should be prepared, who should be consulted in that process, and the duties on Scottish ministers in relation to guidance. These are important matters, providing clarity in the process to be adopted. Presiding Officer, I move Amendment 30 and I urge members to support Amendments 43, 44 and 45. Thank you.
Thank you very much, Minister. Can I call Mary Fee to speak to Amendment 45 and the other amendments in this group?
Can I begin by thanking Claire Adamson for her very kind words and confirm my support for all other amendments in this group. Presiding Officer, Amendment 45 is in line with my earlier Amendment 38 in Group 5 on guidance and will ensure that there is a similar requirement on the Scottish Ministers to provide guidance to support listed authorities in fulfilling their reporting requirements under Section 15. There is no doubt that making the commitments in this bill real, actually incorporating children's rights into service design and delivery, is going to be challenging. After all, we've never done it before. So people are going to need advice and support to help them get it right and to understand what is expected of them under this legislation. So I welcome the Scottish Government's willingness to issue guidance to listed authorities. It is also essential to ensure that there is transparency in relation to the guidance which is issued in support of implementation of this bill. By making this a requirement in the bill and by ensuring that such guidance is widely consulted upon, The bill will ensure that there is buy-in and support for the steps to be taken by listed authorities in the fulfilment of children's rights. And I hope members will agree with this amendment. Thank you.
Thank you very much. Ms Fee, can I call Jamie Green?
Thank you, Presiding Officer. I listened with great interest to the Minister's response to Amendment 30. We will support all the other amendments in this group. We tried to include these two provisions in Stage 2. One was around Scottish ministers and their exercise of powers in relation to prisons and prisoners, and the other was the Scottish Courts and Tribunal Service. I see that there are no attempts to remove the latter. However, the only listed authority which has a duty to report, which references Scottish ministers, is this one, and it's the only one which Scottish ministers are seeking to remove, which is notable. I also pay tribute to any charity who has campaigned on this issue and raised it with us, but I would question whether or not it's necessary to remove specific reference. The argument that it's based around the terms of reporting, 3 years versus I believe it was 6 months, I think is a bit of a red herring, because I think there is nothing stopping ministers themselves reporting regularly. I don't think the addition of this would, as it is currently stated in Stage 2, would elongate the reporting requirements of ministers. But I do take on board the feedback that the organisations mentioned is comfortable with the government's approach on this. What I think it does raise, I think, is an important point that the Minister herself recognised, which is those children who do get caught up in the offending system, and the application of UNCRC will be relevant to them as well. So I just wanted to make that point, that we added this in for good reason at the time, supported by the various external organisations, and I thank the Minister for her update on it.
Thank you very much, Mr Green. And can I call Claire Adamson to wind up in this group?
I'm content to leave it there, Presiding Officer. Thank you.
Thank you very much, Ms Adamson. So in that case, we're going to go straight to the vote. And the question is that Amendment 43 be agreed to. Are we all agreed? Yes. We are agreed. Can I call Amendment 44? Claire Adamson to move Amendment 44.
Moved, Presiding Officer.
Thank you. The question is that Amendment 44 be agreed to. Are we all agreed? Yes. We are agreed. Can I call Amendment 30? This is in the name of the Cabinet Secretary. Minister to move formally. Thank you. The question is that Amendment 30 be agreed to. Are we all agreed? Yes. We are agreed. Can I call Amendment 45 in the name of Mary Fee? Mary Fee to move.
Move, Presiding Officer.
Thank you. The question is that Amendment 45 be agreed to. Are we all agreed? Yes. We are agreed. Turning now to Group 9. This is reporting by the Scottish Parliament. Can I call Amendment 46 in the name of Mary Fee in a group on its own? Mary Fee to move and speak to Amendment 46.
Thank you, Presiding Officer. Amendment 46 in my name would ensure that the Scottish Parliamentary Corporate Body would be required to publish a report outlining how the work of Parliament has met the requirements of this bill. And having worked closely with stakeholders, including Together on this is seen as an issue of great importance to these groups. The Scottish Parliament is a human rights guarantor and should play a leading role in ensuring that human rights promises made to children through the UNCRC and Corporations Scotland Bill are kept by all levels of government. Children do not have the same political or economic power as adults, and it is essential that in its role as a human rights guarantor, the Scottish Parliament pays particular attention to children's rights and ensures that children and young people are fully involved in decision-making on all matters that affect them. Children are impacted by a host of issues, ranging from transport policy to the environment and education. Children and young people have been at the heart of the passage of the UNCRC Scotland and Corporation Bill through the Scottish Parliament. The Equalities and Human Rights Committee has learned a great deal from children and young people through their involvement and is keen that this learning is shared across Parliament. and it is essential that children and young people's involvement in parliamentary business and the democratic process is not limited to a narrow range of topics. The Scottish Parliament must ensure that children and young people's rights are mainstreamed into its day-to-day work and across all policy areas. Members of the Scottish Parliament should make it a priority to engage children in this endeavour. The bill already places a range of duties on the Scottish Government and on the courts. It is only right that the Scottish Parliament should agree to accept duties itself. In requiring the Scottish Parliament to set out what it has done to secure better or further effect of the rights of children and what more it plans to do, this amendment will help to secure the culture change in the Scottish Parliament that we are seeking to achieve across Scotland, and I move Amendment 46.
Thank you very much. Can I call Andy Whiteman to be followed by Alex Cole-Hamilton? Andy Whiteman.
Thank you very much, Presiding Officer. I want to make a few comments on behalf of the Scottish Parliamentary Corporate Body on Amendment 46. The SPCB recognises the aim of Amendment 46 to hold the Parliament to the same standard as other public authorities, but I'd like to make a few comments about how that can best be achieved. I note that the bill explicitly excludes the Parliament from Section 6 of the bill, which provides that it's unlawful for a public authority to act in a way which is incompatible with the UNCRC requirements. This, it appears to me, is not because the Parliament shouldn't be concerned about children's rights. Rather, this exclusion in Section 6 seems to recognise the unique status, structure and functions of the Parliament. I would just say in passing, Presiding Officer, that the next group concerns statements to Parliament about the compatibility of bills with UNCRC. I will not be speaking in that group, but the corporate body has looked at those and is very content with them. Some statutory provisions that apply to other public authorities do apply indeed to the corporate body. For example, the duty to produce a British Sign Language plan, the duty to produce a Gaelic language plan, the obligations of the Freedom of Information Scotland Act. These and other duties fit with the role of the SPCB as an employer, as a provider of services to Parliament, and as an owner of land and buildings. So where statutory duties are appropriate to its functions, it is very correct that corporate bodies should be held to the same standards as other public authorities. However, the corporate body is not a public authority that exists to provide services direct to the public. Its role is simply to provide the staff and the facilities to enable the Parliament to function. It has no role in defining how the Parliament or its committees should conduct their scrutiny and legislative functions. Members, not least committee conveners, would rightly be concerned should the SPCB seek to exert any direction or influence on those matters. And so the duty in Amendment 46 does not seem, therefore, to fit particularly well with the SPCB's role. Subsection 2A makes the corporate body responsible for reporting on matters that are not directly within its control. It's a matter for Parliament to decide its position on legislation and for individual committees to determine their own work programmes and business and how they undertake scrutiny. And it would not be consistent with the normal functions of the corporate body to be responsible for reporting on those. Subsection 2B would appear to require the corporate body to develop its own position on how the Parliament and its committees should, in future, secure better or further effect the rights of children. And it would not, in our view, be appropriate for the SPCB to seek to set policy in this area or to issue guidance. It has never done so, and it has no statutory role to do so. Its own functions and impartiality would be compromised if it did so. So while the corporate body would be concerned about any statutory duty that doesn't fit within its role, I would like, on behalf of the SPCB, to assure Mary Fee and all members that the corporate body is happy to commit to doing what it can to report on the way that the Parliament's activities promote children's rights. The Parliament has shown its commitment in many ways to furthering the rights of children and helping to ensure that their voices and concerns are heard, not least through its public engagement strategy. The corporate body supports all this work and will continue to do so. As members know, the SPCB already produces an annual report. This includes details of a lot of the engagement work that the Parliament undertakes. For example, significant work has been undertaken in Session 5 by the Parliament's Education Services and the newly established Participation and Communities team. This has included much closer working with schools in the Scottish Youth Parliament and hearing from a much more diverse range of younger voices in committees when it comes to the scrutiny of public policy and legislation. Committees have also made considerable efforts to make their reports and material accessible to children and young people. The work of the Equality and Human Rights Committee in this bill, for example, included the production of a child-friendly report. And in projects such as the development of the Parliament's new website, a very significant emphasis has been placed on accessibility. The SPCB is committed, Presiding Officer, to continue to resource the Parliament's participation agenda to make it easier for the Parliament to hear from more diverse voices, including children and young people, to inform its scrutiny work. So on behalf of the SPCB, I am happy to commit to it looking thoroughly at how the annual report can cover achievements and plans for continuous improvement in relation to engaging with children and children's rights. And I hope that this can satisfy the outcomes that some stakeholders in the public rightly want to see as a result of Amendment 46, without, however, placing a statutory duty on the SPCB that does not fit with its role and responsibilities. Thank you.
Thank you, Mr Whiteman. Can I call Alice Cole-Hamilton?
Thank you, Presiding Officer. I rise only briefly to speak in favour of Mary Fee's Amendment 46. This is really important to the children and young people's sector. It's really important to children and young people. It represents in many ways the only way that they have potentially to hold this Parliament to account in terms of making rights real. I understand the concerns that Andy Whiteman has raised, but I don't believe they're insurmountable. And I feel that this is our opportunity to throw our caps over the wall collectively on this issue, to press the SPCB to make rights real within its fabric. And I would urge the Chamber to support the motion, the amendment.
Thank you. I call on the Cabinet Secretary, John Sweeney.
Thank you, President Officer. Can I thank Mary Fee for explaining the purpose and the effect of the amendments that she's brought forward. The Government has been clear throughout this bill process that human rights can only be fully realised in Scotland if all institutions of the state, including Parliament, take action to respect, protect and fulfil the rights that belong to every member of Scottish society. That applies equally to children's rights. As I have previously indicated, I am supportive of provision being made that would bring the Parliament within the provisions of the bill in some way. I have also been clear, however, that this is not a matter for the Scottish Government, but for Parliament itself, and that's why I welcome the initiative that Mary Fee has taken in this respect. In your letter, Presiding Officer, to the Equalities and Human Rights Committee on the 27th of January, you indicated that there are many ways in which the Parliament already seeks to respect and advance the interests and rights of children and young people, and I agree wholeheartedly with that assessment. One of the best features of this Parliament has been its willingness across the Chamber to include and welcome children and young people and to acknowledge, respect and celebrate their contribution to our civic life. In your letter, Presiding Officer, you also noted that the Parliament is in common with a number of public authorities subject to more general planning and reporting duties. I consider that Amendment 46 is in this spirit and will ensure that there is transparency in relation to steps taken by the Parliament to secure better or further effects of the rights of children. I believe this amendment recognises Parliament's role in relation to the protection of human rights in Scotland, and by requiring annual reporting on the Parliament to affirm and embed its reputation, its rightly deserved reputation, as a rights-respecting institution. I therefore am grateful to Mary Fee for bringing forward Amendment 46 and would indicate the Government will support this and would hope that other members would do so too.
Thank you very much. Can I call on Mary Fee to wind up and to press her or withdraw her amendment?
Thank you, Presiding Officer. And can I begin by thanking Alex Cole-Hamilton and the Cabinet Secretary for the very positive and helpful comments they have made. I am grateful for the comments and the explanation that has been given by Andy Whiteman on behalf of the corporate body, and for the consideration that the corporate body has given to this matter. Throughout the evidence sessions, we heard repeatedly the view from stakeholders that this Parliament should be included. Through this bill, we ask of others what we are not prepared to do ourselves. This amendment has attracted a significant amount of interest. And, Presiding Officer, if I'm being perfectly honest, I had hoped that the response from Mr Whiteman would go further. I fully understand the concerns that he has raised, and I have given a lot of consideration. However, his reassurance and explanation falls far short of what I had hoped for and would not fulfil the aims of this amendment. His commitment to look thoroughly is not enough, But more importantly, Presiding Officer, it will not satisfy the many stakeholders who have campaigned on this specific issue. And ultimately, that is who we have a responsibility to, and I will press Amendment 46.
Thank you very much. The question is that Amendment 46 be agreed to. Are we all agreed? Yes. Are we all agreed? Yes. We are agreed. Moving on now to Group 10, compatibility statements. Can I call Amendment 47 in the name of Mary Fee, grouped with Amendment 48? Mary Fee to move Amendment 47 and speak to both amendments in this group.
Thank you, Presiding Officer. Amendments 47 and 48 in my name seek to ensure that all bills introduced in the Parliament meet the UNCRC requirements, not just government bills. Effective scrutiny of legislation is essential in protecting, respecting and fulfilling children's rights in practice. The bill already requires scrutiny of the compatibility of Scottish Government primary and secondary legislation by requiring ministers to undertake a CRWIA and to make a statement of compatibility. At present, the bill does not make similar provision for non-government bills. The Scottish Government has been clear that it considers it appropriate for Parliament itself to consider whether these requirements should apply to members' bills and other non-government bills. Given the Scottish Parliament's role as a human rights guarantor, it is clearly appropriate for this duty to apply to all bills introduced to the Scottish Parliament, not just government bills. As such, these amendments will address this inconsistency and ensure effective scrutiny of all legislation introduced to the Parliament, and I move Amendment 47.
Thank you very much. And can I call the Cabinet Secretary and other colleagues wish to comment on this section? Cabinet Secretary.
Thank you, President Officer. I'm grateful to Mary Fee for explaining this amendment. President Officer, the bill on introduction required Scottish ministers to make a compatibility statement in relation to Scottish Government bills. Amendments 47 and 48 are complementary to this and will extend the requirement for statements of compatibility to all public bills introduced into the Scottish Parliament. I think this is supportive of the ambition that children's rights are fully respected, protected and fulfilled in all legislation passed by this Parliament. Whilst the bill will not require that a children's rights and wellbeing impact assessment will be needed for non-government bills in the same way as for government bills, I believe Amendment 47 will support and encourage use of such impact assessments in relation to non-government bills. Adopting this practice would clearly help members to come to a view about the impact of a bill on children's rights. This issue was not legislated or not proposed to be legislated for by the Government at the outset of introduction of the bill for all proper reasons which Mary Fee has recounted to Parliament, and I'm grateful once again to Mary Fee for addressing that issue on Parliament's behalf, which I think is important that is done by a member who is not a member of the Government. I therefore support Amendments 47 and 48 on the basis that they complement and strengthen the bill, and I hope members will also support those amendments.
Thank you. Mary Fee to wind up or to press or withdraw?
I have no further comments and I'll press my amendments. Thank you.
Thank you. The question is that Amendment 47 be agreed to. Are we all agreed? Yes. Thank you. It's agreed. Can I call Amendment 48? Mary Fee to move?
Move, Presiding Officer.
Thank you. The question is that Amendment 48 be agreed to. Are we all agreed? Yes. Turning now to Group 11. This is on legislation that sections 19 and 20 apply to. Can I call Amendment 49 in the name of Alexander Stewart, grouped with Amendments 50, 51, 52, 53 and 54. Alexander Stewart to move Amendment 49 and speak to all the amendments in this group.
Thank you, Presiding Officer. I move Amendments 49 and 50, and they are probing amendments. They seek to provide the Scottish Government with the opportunity to explain why they believe that including acts of the UK Parliament in Section 19 are within the competence. The effect of Amendment 49 is to delete Section 2A2 by existing acts of the UK Parliament in the scope of Section 19. Amendment 50 makes a further consequential change to Section 19. Section 19 provides the legislation which will be in the competence of the Scottish Parliament to make and must read that given the effect in any way of the competence of within the UNCR requirements. Legislation is defined in Sections 2A1 of the Act of the Scottish Parliament and subsequently 2A2 in the Act of Parliament. There is an issue that the application in 19.1 of the Acts of the Scottish Parliament. There is a similar provision within Section 102 of the Scotland Act 1998, which states that the provision of the Act of the Scottish Parliament is to be read as narrowly as required within its competence. However, some may argue that this could be challenged as it is within the competence of the Scottish Parliament to apply the rule under Section 19.1 of the provision of the Act. This is because Acts of Parliament are interpreted in the accordance of the Interpretation Act of 1978. Furthermore, for the reference of Act of Parliament in Section 2A1, that applies for the future as well as the past Acts of Parliament. Questions may be raised into the future as to whether Section 2A1 will be considered in Section 28(7) of the Act of Scotland in 1998. The provision of the UK Parliament has the power to make laws on the Scottish Act, and the UK Parliament might have interpreted in the Act, and therefore I move Amendments 49 and 50. Presiding Officer.
Thank you very much, Mr Stewart. Does the member wish to speak in this section? Okay. In that case, I'll call the Cabinet Secretary, John Swinney.
Officer, amendments 49 to 50 and 52 to 54 would significantly undermine the protection for children's rights in Scotland, which this bill seeks to put in place, and are at odds with the Scottish Government's ambition that the bill should provide for the highest level of protection possible for children's rights within the powers of this Parliament. It is of fundamental importance that any incompatibilities in legislation which it would be within the power of the Parliament to make can be remedied. The amendments proposed by Mr Stewart would remove from the protections offered by sections 19 and 20 of the bill all acts of the United Kingdom Parliament which fall within the competence of this Parliament. That would, for example, include all pre-devolution legislation over which competence has been transferred. To help members understand the significance and the scope of that particular provision, that would put acts such as the Children's Scotland Act 1995, the Scottish parts of the Police Act 1997, the Rehabilitation of Offenders Act 1974, the Education Scotland Act 1980, the Education Scotland Act 1996, the National Health Service Scotland Act 1978, the Social Work Scotland Act 1968, the Family Law Scotland Act 1985, the Children and Young Persons Scotland Act 1937, the Registration of Births, Deaths and Marriages Scotland Act 1965, the Criminal Procedure Scotland Act 1995, and the Further Education Scotland Act 1992, all of them out of scope of this Parliament. So these are very wide-reaching amendments which would significantly undermine the protection for children's rights which the bill seeks to put in place. Now, I was somewhat perplexed when I heard Mr Stewart talking about these as probing amendments, because I received a letter on the 4th of March from the Secretary of State for Scotland, in which, and I quote, the Secretary of State for Scotland requested that the Scottish Government table an amendment that makes it clear that Westminster legislation is removed from the scope of sections 19 to 21. So here now members will not be surprised to hear that in my reply to the Secretary of State for Scotland on the 9th of March, I told the Secretary of State we would be doing no such thing. So I'm therefore surprised to hear this marshalled as a probing amendment in front of Parliament when there was nothing probing about the Secretary of State's letter to me of the 4th of March. In fact, the word I would use to describe the Secretary of State's letter was menacing. And so therefore, I think what we've had a little display of today is the fact that where the Secretary of State for Scotland thinks he can write menacing letters to the Deputy First Minister of Scotland, seeking to exempt key pieces of legislation that are integral to the legislative competence of this Parliament, he can then send his functionaries in to do his bidding for him. at a later stage. So what I think this demonstrates is that there is underway a very, very, very orchestrated and sustained assault on the powers of this Parliament, which are not only, I'm not surprised, they're being cooked up in the office of the Secretary of State for Scotland in, of course.
Jamie Green.
I make no apologies for being a functionary in this chamber. Members in this place have every right to come to a stage-free debate with amendments. The Secretary of State for Scotland, who doesn't sit in this Parliament, is perfectly within his rights to represent the UK Government in his correspondence with the Scottish Government, which he has done. Now, the perception of that, it's entirely up to you, Cabinet Secretary, how you perceive those letters, the tone thereon, and indeed in what you reply to them with. But what the point that we're making today, and these are reflected by the Law Society of Scotland, who shared some of those concerns, valid concerns about the interplay between some of the provisions of this legislation and UK legislation as well. And those were valid concerns that were raised throughout the process. I talked about this at stage one in a constructive way, and I said we would approach this constructively, and we have. It's unfortunate the tone the Cabinet Secretary has taken this afternoon, given light of the content. We said we would support this bill throughout, and will do so today, and we'll talk about that in the stage-free debate. But the very message that the Cabinet Secretary is giving off, that we are somehow not trying to ensure that this bill is watertight, is unfortunate and a little bit demeaning, I have to say.
Cabinet Secretary.
Thank you, President Officer. I fear I may have touched a raw nerve this afternoon in what I'm saying, and just for the record, I am very much appreciative of the fact that the Conservatives have made clear their support for the bill, and the Secretary of State for Scotland, for completeness, so that I can do full justice to the argument of the Secretary of State for Scotland. He does put on the record in the letter that protecting vulnerable children is an absolute priority for the United Kingdom Government, and across the UK, different legal protections in place for children are recognised as being amongst the strongest in the world, and measures are integrated in our respective legislation. So that's me giving some other comments from the Secretary of State for Scotland's letter. But my point is that if I had followed the letter from the Secretary of State for Scotland, I did as he requested, and if we were to support these amendments by Mr Stewart, probing or otherwise, we would be limiting the protections available for children and young people, and that contradicts the direction of the bill, which I know Mr Green and the Conservatives support. So what I think we have touched on this afternoon is, and what these amendments have given me the happy opportunity to be able to point out to Parliament and to the public, is that there is an orchestrated attempt underway in the United Kingdom Government to hem in the powers and the responsibilities and the exercise of those responsibilities on behalf of the Scottish Parliament, as legislated for by the United Kingdom Parliament in the Scotland Act 1998, which I am one of just 3 remaining members in this Parliament, I think, who voted for that legislation in the House of Commons. And we did so because and I see Mr Stewart is here. It's going to be a sadder place, this Parliament, without Mr Stewart in the next parliamentary term. My colleague Rosanna Cunningham is the other Member of Parliament who voted for this legislation in the House of Commons. And so we voted for that legislation, and the House of Commons and the House of Lords voted for that legislation to create a Parliament that was able to exercise in full its responsibilities in these areas of devolved competence. And we now see there is a pretty orchestrated attempt underway by the United Kingdom Government to interrupt that, whether it's the Internal Market Bill that my colleague Mr Russell has been involved in a gentle debate about, or whether it's the actions that have been set out to us in this letter from the Secretary of State for Scotland. Whatever it is, I think we're pretty clear. There's an organised threat to the powers of this Parliament, and this Government will have none of it. So, Presiding Officer, in case there is any uncertainty in anybody's mind, I oppose Amendments 49, 50, 52, 53 and 54. This Government opposes these amendments, and I hope members from across the parties will join us in sending a strong signal that we oppose them too, and that we're determined to protect the powers of this Parliament.
Thank you, Cabinet Secretary. Mr Stewart, would you like to make any comments by way of winding up?
Thank you, Presiding Officer. Yes, I would. As my colleague Jimmy Green indicated, these amendments came from the Law Society of Scotland. And Mr Swinney can make some strong representation about what is taking place in the UK Parliament, but the Law Society of Scotland felt that these amendments should at least be discussed and be given some airing during this whole process within this bill progressing, Mr Swinney. So I think that it is appropriate for me to put them forward today and to listen to what has been said this afternoon. But can I assure the Council Secretary, there is no malice in this whole process, and I'm not at the behest of anybody from Westminster. If I have taken some advice, it is from the Law Society of Scotland, who have today suggested that these amendments, as I say, should be put in place, and I am being more than happy to put them forward. I note the comments that the Cabinet Secretary has made, and I take that on board, but I feel that at the same time they should have been given the opportunity to be aired. Thank you.
And could I ask Mr Stewart, does he intend to press Amendment 49?
No.
Mr Stewart is going to withdraw Amendment 49, if no one objects. Thank you. So, and can I also confirm, Mr Stewart, that you don't intend to move Amendments 50, just Amendment 50, not moved?
Correct.
Thank you. Turning now to Group 12, this is on the role of the Lord Advocate and the Advocate General for Scotland. Can I call Amendment 51 in the name of Alexander Stewart? This is grouped with Amendments 55, 56, 57, 58 and 59. Alexander Stewart to move Amendment 51 and speak to all the amendments in this group.
Presiding Officer, I think under the circumstances I will not move these, because once again it may well be misinterpreted that I am trying to do something which is not the case, as I say, and as I say, these amendments were also given to me by the Law Society of Scotland, so I'm not going to give the opportunity for that to take place. Thank you, Presiding Officer.
Can I just confirm, Mr Stewart, then, that you're not going to move Amendments 51 to 59 because they're coming consecutively? Confirmed. Thank you. So we turn now to Group 13. This is on Rules of Court. Can I call Amendment 31 in the name of the Cabinet Secretary, grouped with Amendments 32 and 33, and Minister Marie Todd to move Amendment 31 and speak to all the amendments in this group?
Presiding Officer, the amendments in this group make minor technical changes to the Bill's provision about rules of court. Amendment 33 adjusts Section 37 of the Bill to further clarify that existing powers to make rules of court may be used to make provision for the purpose of this Bill. Amendment 31 removes the definition from the Bill's general definition section, which is not needed because rules of court are only referred to in Section 37, and Amendment 32 is consequential on that change. I move Amendment 31.
Thank you very much. There's no other members who have indicated they wish to speak in this group, so we'll go straight to the question. The question is that Amendment 31 be agreed to. Are we all agreed? Yes. We are agreed. Can I ask the Minister to move Amendment 32?
Moved.
That is moved. The question is that Amendment 32 be agreed to. Are we all agreed? Yes. We are agreed. Can I call Amendment 33? Minister to move?
Moved.
Thank you. The question is that Amendment 33 be agreed to. Are we all agreed? Yes. We are agreed. Turning now to Group 14, can I call Amendment 34 in the name of the Cabinet Secretary? This is grouped with Amendment 35, and again Minister Marie Todd to move Amendment 34 and speak to both amendments in this group.
Presiding Officer, the Scottish Government has been clear in its desire to see the Bill commenced as soon as it is practically possible. At Stage 2, the Equalities and Human Rights Committee supported provision that will commence the Bill 6 months from Royal Assent in preference to our amendment to commence within 12 months. We've considered this carefully and have concluded that we can indeed support commencements within 6 months of Royal Assent. And as I made clear at Stage 2, it is the intention of the Scottish Government that the First Children's Rights Scheme is available to support commencement of the Bill. Accordingly, Amendments 34 and 35 seek to build flexibility back into the bill to enable the Scottish Ministers to commence some provisions of the bill by regulation before the rest of the bill will commence. This will not affect the overall timetable because Section 42 will still mean that the bill will automatically come into force 6 months from royal assent, but it will mean that there is flexibility within that timetable, particularly to ensure that the practical work needed to commence key provisions is undertaken swiftly. Amendments 34 and 35 therefore will enable the orderly and effective commencement of the bill. I move Amendment 34 and encourage members to support it and Amendment 35.
Thank you. And I call Alice Cole-Hamilton.
Thank you very much, Presiding Officer. I rise to speak in favour of Amendments 34 and 35. I move the original amendment at stage 2 to have commencement take place within 6 months rather than 12. And I congratulate the Government for this amendment and their ambition here. The fact is that children and young people in Scotland want the rights and protections that incorporation of the UN Convention on the Rights of the Child affords them yesterday. They have wanted it for many, many years. We've started talking about this while I was still a child, and I'm really delighted to see where we are today. The concerns I think that were raised initially were around the ability of public bodies to be ready for this and be ready for the obligations that this bill and this the incorporation of this convention, as it will be, would ask of them. But the fact is that they've had this in the offing since the early days of 2012, when we were in the foothills of the 2014 Children and Young People Bill. They have been preparing for this, and they have been, I think, pulling together collectively towards this, this shared aim. So I don't think we've anything to fear by, again, pushing for earlier commencement. I'm very glad to see that this amendment will allow that earlier, if it is indeed possible to do so in advance of the 6 months. Thank you.
Thank you very much. And there's no other member indicated they wish to speak. Does the Minister wish to add anything by way of conclusion?
No, thank you.
Thank you. So we'll go straight to the question. The question is that Amendment 34 be agreed to. Are we all agreed? Yes. We are agreed. Can I call Amendment 35, Minister, to move?
Moved.
Thank you. The question is that Amendment 35 be agreed to. Are we all agreed? Yes. We are agreed, and that ends our consideration of amendment. Now, at this stage, as members will be aware, I am required under standing orders to decide whether or not, in my view, any provision of the bill relates to a protected subject matter, that is, whether it modifies the electoral system or franchise for Scottish parliamentary elections. In the case of this bill, it does no such thing. Therefore, the United Nations Convention on the Rights of the Child and Corporation Scotland Bill does not require a supermajority to be passed at stage 3. We're going to move on shortly to the debate on the bill. There's going to be a slight pause. Can I just ask all members, remind all members to follow the social distancing rules? There's quite a few chats breaking out, people coming together quite close, not wearing masks and so on. So just encourage members, wear the masks, follow the one-way systems, don't cross in front of people at the desks, and just follow the rules. Thank you. A short pause before we proceed. Sorry, colleagues, I'm going to rethink matters. I'm actually going to call a 5-minute suspension before we move on. A 5-minute suspension. In fact, we'll call it till 6:10. So we're suspended and we'll call members back here at 6:10. Apologies for not recognising the needs of other members in the chamber.
can I say I'm just about to start, so in another minute, could I make sure all members who are in the debate are in the chamber, please? Thank you. The next item of business is a debate on motion 24369 in the name of John Swinney on the United Nations Convention on the Rights of the Child Incorporation Scotland Bill at stage 3. And those members who wish to speak in the debate, press the request to speak buttons now, and I call on Marie Todd to speak to and move the motion. Minister, please.
Presiding Officer, by incorporating the UNCRC directly into Scots law, we are pioneers. The first administration in the UK and the first devolved legislature anywhere in the world to do so. We should all be proud of that. The UNCRC is the most widely ratified international statement, but very few have taken the journey that Scotland has. And I want to thank everyone who has walked with us on this journey. Our first steps involved establishing a Scottish Commissioner for Children and Young People, and I want to thank Kathleen Marshall, Tam Bailey and Bruce Adamson for advocating for incorporation. I also want to thank all the organisations that have campaigned for incorporation. This campaign was made more potent when the Scottish Alliance for Children's Rights was formed in 1996. Now known as Together Scotland, the Alliance has been pivotal to the developments of this bill, and we are hugely grateful to Juliet Harris and all Together staff and directors for their efforts. I'm also very aware that there are many MSPs, past and present, who have campaigned for children's rights, needs and interests, moving us on the journey to get here. Thank you all. Here, Presiding Officer, is a landmark occasion to be celebrated. During any legislative process, it's easy to lose sight of the fundamental purpose of that bill. This bill sets out the architecture needed to incorporate the UNCRC, the mechanics of how to do that, and the mechanisms needed to resolve the circumstances when children's rights might not be met. That is right and proper. We had to ensure we put in place all the measures needed to get incorporation right. It's not a simple undertaking, after all, but we should also focus on the actual rights that we're incorporating into law and what they will mean for our children. This bill will mean the full range of children's rights within the powers of this Parliament are woven into the fabric of our law, our policy and our public life in Scotland. Incorporating Article 12 will mean that children have the right to be involved and heard in relation to the decisions that affect their lives. Article 23 will ensure that children with disabilities have dignity, self-reliance and are able to actively participate in their community. Article 3 will ensure that children's best interests are a primary consideration. That means we will all need to act to change things. When budget is required to support services which enable the fulfilment of children's rights, it'll need to be provided. When families have unmet needs, they should no longer have to fight for change. It becomes our duty to make change happen. There is a huge cultural shift I want this legislation to help deliver. But let's not forget the small changes which will also make a difference to children's everyday lives and which can send clear and unequivocal messages about what a child-centred society truly looks like delivering on the right to play. How we've had to live during the pandemic to help suppress the virus has brought into sharp relief the importance of play for children and the huge sacrifice that we have asked them to make to keep all of us safe. So I hope that this bill finally sees the no ball games allowed signs all across Scotland replaced with children welcome to play here signs instead. If we are to effect the change that we seek with this bill, then promoting awareness of children's rights under Article 42 is key. Raising awareness and understanding of children's rights will create a lasting legacy. It'll mean that the children of today grow up to empower the children of tomorrow. And make no mistake, this matters to Scotland's children. In every Scottish local authority area, thanks to UNICEF's wonderful Rights Respecting Schools programme, there are tens of thousands of children who have grown up learning in environments that are rights aware and which respect their rights. Through the work of Children in Scotland, the Children's Parliament and the Scottish Youth Parliament, children and young people have had their say throughout this process. And I thank every one of them for sharing their thoughts and opinions. One of the privileges of being Children's Minister is that I get to hear directly from children of all ages and see firsthand their understanding and awareness of what rights are and why they matter. Their tenacity and passion never fails to impress and indeed humble me. Their commitment to advancing their own rights and the rights of others to improving this bill has been an honour to witness and to support. How much this means to children and young people is best expressed in their own words. Abigail, a young advisor to the Commissioner's Office, said incorporation is a way of children having their voices heard. They know that they will be listened to and they know that they matter. As part of the Children's Parliament evidence to the bill's consultation last year, a child said, "I think you should make children's rights law because it will keep a lot more children safe." Presiding Officer, this bill will significantly advance children's rights across Scotland. Parliament passing this bill puts us in the vanguard as truly a world leader in children's rights. And it doesn't represent the end of the journey in making children's rights real. Far from it. It is incumbent upon all of us to ensure that the bill's ambitions are translated into real-life improvements which transform the lives and life chances of our children and young people. Today, we are delivering a revolution which heralds a new era for this nation. In the words of Lady Bird Johnson, the wife of US President Lyndon B. Johnson, who passed into law vital civil rights, children are likely to live up to what you believe of them. Presiding Officer, I believe in Scotland's children, and I move that the Parliament agrees that the UNCRC Incorporation Scotland Bill be passed.
Thank you very much, Minister. Now calling Alexander Stewart over the Conservatives. Mr Stewart, please.
Thank you, Deputy Presiding Officer. I'm delighted to be able to open for the Scottish Conservatives this afternoon on Stage 3 debate on the United Nations Convention on the Rights of the Child Incorporation Scotland Bill. Protecting and safeguarding the rights of our children is fundamentally important. We must not only respect the value their contribution that they make, but listen to their views and involve them in the decisions that directly affect them. And I'd like to pay tribute to the committee I sit on, the Equalities and Human Rights, because they have taken huge consultation to ensure that there has been robust discussion and there's been robust debate to ensure that children's views were taken forward while we were going through this process. The United Nations Convention on the Rights of the Child is the single most important ratified international human rights treaty in the history of the world, and has been described as, without question, one of the complete statements on human rights ever produced. And that is the case, Deputy Presiding Officer. There are 4 key principles of the non-discrimination in the best interest of the child, the right of survival and development and the views of the child, and to ensure that they are they're supported and subscribed and is robust. And the United Nations Rights of the Child is nothing new to Scotland and to the United Kingdom. As we are well aware, the United Kingdom ratified the treaty now nearly 30 years ago. And in the Convention, it talks about ensuring that there are familiar and that children are understood and listened to. And it is something that is educated and teachers across schools and colleges make sure that young people are well aware of what is taking place within this process. And many steps have been taken both here in Scotland and across the United Kingdom to protect and enhance the rights of children. But the ratification of this international treaty does not automatically give it the effect under domestic law. And that is why we are here today considering this extremely important legislation within this Parliament. And it's right that we have to ensure that that takes place, and it's vitally important. And it is clear that there is not only a broad consensus on the objectives across this chamber, but also across the wider civic society within Scotland. The bill takes the necessary steps to ratify the lack of enforcement and ensures that UNCHR is incorporated into Scots law. And that directly makes the method and adopts the bill, and that will ensure that there is a maximum approach, and that's very much to be welcomed. There are 2 things combined with undoubtedly ensure that the rights are afforded under the UNCHR, and that is to enhance our domestic law and the full extent as possible. But if this bill is to work, rights are enshrined and must be enforceable. And in my view, it is right that the bill is ensuring that public authorities who fall and fail to comply with the UNCHR requirements under the new legislation could find themselves challenged within the courts. And this could give them and the judicial review that the Court of Session will have to involving UNCHR requirements with any proceedings. And the role of the Children and Young People's Commissioner is also incredibly important because they are the guardian of the children's rights here within Scotland. And they must be allowed to advocate on behalf of children and give the views of public authorities and ensure that if anything does go wrong, that is challenged. And I believe that the measures of the bill which will allow the Commissioner to bring court proceedings on behalf of a child will enhance that role. And I note the concerns that were raised by the committee at the Stage 1 report. And this has been reflected in the effectiveness of the action that's been taken, and we welcome that. I also welcome that the bill has amended at Stage 2 that reflects with comments on the children now were given an opportunity to express their own opinion on any of that. And it's absolutely right that in the absence of any evidence to the contrary, children should be presumed to be able to express their views on matters that are directly affecting their own lives. And this does take place within this. And it is also understood that the difficulties and technical challenges that when importing such a law into domestic law are already there. So while we take on board many of the objectives that are taking place here, we did discuss much of this when we were discussing things at Stage 2. And while we should not be obsessive about the incorporation that took place, but while we saw at Stage 2 amendments were agreed and came forward. And these are there to significantly improve the bill and have provided additional and necessary clarity. And we've had that once again today, Deputy President, the clarity has been put into place. One amendment in the wording of the courts considered that the UNCR should be strengthened, and that went from the may to the must. And I think that once again showed the strength of feeling that was taking place. It was disappointing to see that the SNP members at Stage 3 did want to try and move out some of the ministerial authorities. But in saying that, as I say, we and the Conservatives are happy to support things. So in conclusion, Deputy Presiding Officer, we in the Scottish Conservatives are happy to support the bill and have done at all stages through and here today. And whilst we remain some issues. We have successfully managed to improve many aspects of the bill and the amendments that we put forward. We acknowledge the work that's taken place by many parties and many people, not just within this chamber, but outside who have contributed. This bill does a job of incorporating into Scots law. It is incredibly important that this bill delivers on its full potential and protects and enhances the rights of children and young people across Scotland. And I am very happy to support it here today. Thank you, Deputy Presiding Officer.
Thank you very much, Mr Stewart. And I call on Mary Fee to open for Labour. Ms Fee, please.
Thank you, Deputy Presiding Officer. And as a member of the Equalities and Human Rights Committee, I am delighted to open this debate for Scottish Labour today. And I'd like to begin by thanking the committee clerks and the bill team for their extremely hard work on this piece of legislation. They have worked tirelessly for the last few weeks to ensure that we are able to reach the final stage of this bill in a shorter time frame than we had originally anticipated. This bill is a fantastic example of what we can achieve on issues of human rights when we do work together. The evidence that we received throughout our evidence sessions was insightful and informative, and this bill would be nowhere near as strong without the unwavering efforts and support and advice of the third sector organisations and individuals. I want to give special thanks to Together, who have given me great advice over the last few months. They have a wealth of knowledge, and their work to include children in the decision-making progress has been nothing short of inspiring. This debate today will be the final debate I take part in as a member of this Parliament, and I am honoured that it is on such an important piece of legislation, as children's rights are an issue that I have been championing for many, many years. And I have spent much of my time in Parliament focusing on equalities and human rights, so I could not think of a better way to sign off. We all have our differences of opinion in this chamber, but one thing I am sure we all have in common is our unwavering commitment to protecting and respecting our children with every fibre in our bodies. And this legislation allows us to do this. It builds on an ethos of putting children first in every single decision that we make. We can get more right for every child when they have specific protection through legislation. And our children have had an incredibly difficult year, one in which they have felt confused, they felt lonely, and they felt powerless. But I want to remind them that they are not alone and that they will be heard. And this bill will not only strengthen children's rights in Scotland, but it will also give children the confidence to use their rights so that they can feel safe and respected. And we have worked very hard at committee to ensure that this bill is strong and robust. Every decision that we have made has been scrutinised, and I am glad that we have been able to achieve cross-party support for such a crucial piece of legislation. And I'm grateful for the support that I received at stage 2 for my amendments and for the ongoing dialogue that I have had both with government and with stakeholders in order to lodge my amendments today. My amendments will provide additional clarity and will strengthen the bill. And, Presiding Officer, I have worked closely with the Gypsy Traveller community, children of prisoners and transgender people during my time in Parliament. And I am satisfied that this bill, in its amended form, explicitly includes them. This bill is a shining example of devolution at work. It's so important for us to use the powers of this Parliament. With devolved power in our hands, we can put that power in our children's hands. The incorporation of the United Nations Rights of the Child into Scots law is a first for the UK, and one that we should be rightly proud of. And in coming to a close, Presiding Officer, I cannot express just how important this piece of legislation is for our children. This bill may have been developed in this Parliament by adults looking to leave the world a better place than the one we inherited. But the true owners of this bill are our children and our young people. And in leaving this Parliament, the best parting gift I can give is empowerment, protection and respect to all of our children and young people through the passage of this monumental bill tonight. Thank you.
Thank you very much, Ms Fee. And I understand you're closing for Labour, and that was your penultimate speech. Well done, and you've got a final speech to come. And now Colin Patrick Harvey, please, to close the Green Party, please.
Thank you, Presiding Officer. Well, I was going to congratulate Mary Fee on her final speech, but I congratulate her on her penultimate speech, and I look forward to her final one. Certainly, her commitment to equalities is something that's been consistent throughout her time in the Scottish Parliament, and I think she will take with her the respect of the great many people whose lives she has worked to improve while she's been a member of this Parliament. Presiding Officer, this is a truly historic moment for Scotland, and I think it's fitting that passing this bill on the UN Convention on the Rights of the Child is one of the final acts of this session of Parliament, a session which included Scotland's Year of Young People. In passing it, it's worth reflecting for a moment on how our rights are developed, how they come to be given status in our society, because the UK is an outlier by European and international democratic standards. It doesn't have a written constitution that sets out the basic and fundamental rights of the people. That's a result of the UK's historic development. It's what happens when your recent history lacks a moment of revolution or sweeping reform. The central pillar of the UK constitutional order, the sovereignty of the UK Parliament, was established following struggles between landed elites and the Crown, not a claim of the wider population's rights. And the trajectory the current UK government has us set on is one toward the erosion of pre-existing rights, not the enhancement and deepening of rights. A timely example to mention is the Istanbul Convention on Combating and Preventing Violence Against Women, which the UK has signed but still not yet ratified. When the UK government is no trusted guarantor of our basic rights, defending and improving those rights here in Scotland becomes a necessity. So I welcome the fact that this historic act that we're passing today will be followed by another, a Scottish Human Rights Act. Passing this bill today will give Scotland the most exciting and innovative children's rights legislation anywhere in the world. Those are the words of Children First, and I very strongly agree. The UNCRC incorporates both social and civil rights side by side. It seeks to overcome the historic division between those rights that has characterised many international rights treaties in recent decades. That was an artificial division, one that's often acted to undermine protection for social rights, particularly since the development of neoliberal economics and austerity. Even in places where social rights do have a stronger basis than in the UK, there has been a trend towards subordinating them to economic principles. This trend must be challenged, and the fundamental importance of social rights must be affirmed as core constitutional principles. So by transposing the social rights in the UNCRC into domestic law, Scotland can contribute to this effort. We can ensure that the courts here give due regard to those rights and develop case law around them. And of course, by enshrining them in law, we're creating a strong incentive for them to be respected sufficiently that children and young people don't need to seek redress through the legal system at all. The Greens are certainly glad to see that the bill in its final form continues to take a maximalist approach, ensuring that the UNCRC rights are incorporated to the greatest extent possible. This will include ensuring that all acts of the Scottish Parliament are compatible with UNCRC rights and provide the courts with the power to ensure that acts are compliant, both past and future. It will enhance the power of the Children's Commissioner, particularly with regard to raising proceedings in the public interest. It will also create a children's rights scheme, one of the most innovative and important aspects of the bill. There is, after all, little value in a right which is not known about and cannot be exercised. Given the barriers that children face to having their voices heard, this scheme will be an important tool to support their active participation in decisions that affect them, to raise awareness and promote their rights, and to consider the rights of children in budgeting processes. Considering the possible impact of this bill, we could look, for example, at last year's SQA assessment scandal as one example. It's quite clear that a robust, participative assessment of the impact on young people's rights would have stopped that grading model long before the results were issued. That's exactly the kind of practical application of the UNCRC which will make a real difference in future. And I would strongly suggest to the SQA that they follow such an approach in the consultation process they've just launched on the question of appeals to this year's grades. Presiding Officer, passing this bill will be a landmark moment in the history of our Parliament. It's the culmination of over a decade's work by a great many people who can feel rightly proud of the work they have done to bring us to this point. And it will be a privilege to vote yes at decision time tonight.
Thank you, Mr Harvey. I now call out Cole Hamilton for the Liberal Democrats. Mr Cole Hamilton, please.
Thank you very much, Deputy Presiding Officer. It gives me great pride to rise in support of this bill tonight. But before I do, I want to say a word about my good friend Mary Fee. It's because of Mary Fee that I know the French word for sellotape after I helped her fix her glasses on a committee trip to Strasbourg. It's because of Mary Fee that children of prisoners will always be considered now going forward in terms of sentencing. And it's because of Mary Fee that gypsy travellers will remain in the consciousness of this Parliament for a long time after she has left it. But this Parliament and this chamber will be the poorer without her. Presiding Officer, this is an emotional day for me. I've spent much of my entire career campaigning for children's rights. And I want to take a moment to recognise, in particular, the contribution of my friends, the Children's Commissioner Bruce Adamson, of Juliette Harris, who's the director of Together, an organisation I was proud to chair, and in their commitment to making this happen today. I also want to recognise other friends like Chloe Riddle and Mark Ballard, but also the many, many children who have brought us to this point today. I thank them for their candour in speaking to our committee and their maturity in what they told us. I have clashed with this government on children's rights, sometimes very publicly, but I want today to congratulate them. Today, Scotland joins a more progressive and enlightened family of nations. We should all be justifiably proud of that. We should also be proud of the fact that we have in this parliamentary term extended equal protection that will end physical punishment of children and raise the age of criminal responsibility. That these things should fall in my first term of Parliament, well, that's hugely satisfying, but we know there is still a way to go. 7 years ago, I told the Education and Culture Committee on behalf of the children's voluntary sector that the most elegant solution against the international standard is to incorporate the United Nations Convention of the Rights of the Child into Scots law. Until we do something like that, I said, or we build on the provisions into the way in which we make policy, we will forever be behind those countries that have already incorporated the UNCRC. Presiding Officer, we have met that test today. By incorporating the UNCRC, it will ensure that the rights of our nation's children are not just respected and protected in the law of Scotland, it will ensure that public authorities are legally required to bake in the consideration of those rights into all of the work that they do. And I'm really pleased that this is going to happen as swiftly as possible. The UK ratified this convention when I was still a child. Public authorities have seen the direction of travel here from the early foothills of the Children and Young People Bill back in 2012. They've had nearly a decade to get their houses in order, and they are ready for it. And children and young people wanted this yesterday. Presiding Officer, it's one thing to pass a bill like this. It's another to live it year in and year out and deliver the intent behind it. And no matter how good any piece of legislation is when written, it is only as good as its implementation. That's why I welcome the commitment of ministers to come back to Parliament to report on the evidence on rights transgressions in our communities and in our public bodies, because in order for this legislation to be meaningful and fulfil its potential, then it must be a living document, and we must keep it under review in perpetuity. This Parliament has a duty to improve the future of our children. by making sure that their rights are embedded across all policy areas, with a policy focus on direct engagement in children and young people, making real their Article 12 rights. By so doing, the Scottish Parliament can build upon the positive steps taken by our committee and the work of many other committees in trying to involve children in the work and the efforts of policy development. Presiding Officer, the issue of children's rights is an urgent one. For every day that we went by without their rights being enshrined in law, then we exposed our children to many kinds of risk. I am delighted we are moving so swiftly in its implementation now. I'm grateful to colleagues across this chamber for their dedication to this bill and for putting the needs of Scotland's children at the heart of this debate and this discussion. Presiding Officer, I'll finish with this. Nelson Mandela once said that there can be no keener reflection of a society's soul than the way it treats its children. In the pages of this bill, we are finally reaching the measure of his test, and I will take great pride in supporting it tonight.
Thank you very much, Mr Cole-Hamilton. Open debate, and I call Ruth Maguire to be followed by Joe Fitzpatrick. Ms Maguire, please.
Incorporation is a way of children having their voices heard. They know that they'll be listened to, and they know that they matter. A lot of young kids feel overlooked in society as a whole, but incorporation of the UNCRC is saying, you're here, we see you, and we're helping you out. Having any knowledge of that is really going to do the world of good for a lot of children. Those are the words of one of the Children and Young People's Commissioner's young advisors. Presiding Officer, what has been a really difficult year for everyone, but perhaps particularly for our children and young people. It's an absolute joy to be standing in our Scottish Parliament and speak in favour of this landmark bill. I'll congratulate my committee colleague Mary Fee on her penultimate speech. We were even doing that differently, and I just want to commend her commitment to justice and fairness and equality. She's made a difference in her time here, and she'll be missed, I'm sure. I'd like to sincerely thank the Deputy First Minister, John Swinney, and Children's Minister, Marie Todd, for the leadership they've shown in taking a maximalist approach to incorporation. I thank colleagues and clerks on the Equalities and Human Rights Committee for their hard work and commitment, particularly those who never missed the early starts or the late finishes or indeed the Saturdays to ensure that the voices of children and young people have been heard and acted on. We didn't accept the term hard to reach when we were planning our participation, and no public authority should ever describe any child or young person like that. It's incumbent on us to reach out and listen to all children. And on that note, I thank the outreach team who facilitated the events that enabled us to speak with and hear from children and young people. My biggest thanks, though, goes to all those children and young people and their supporters, who first of all campaigned so hard for this for decades, and then generously and openly shared their thoughts, their experiences, and challenged and helped us to improve this bill. There are not many things in politics that command universal welcome, but almost everyone who shared their views with my committee through submissions, oral evidence, or participation, whether they were academics or children and young people, had one thing in common: overwhelming support for this bill. The reason? When this bill delivers in practice what it's setting out to do, it will put children's rights at the very centre of public authority decision-making. That will make a tangible difference to the lives of Scotland's children and young people, all of Scotland's children and young people. Now, that consensus and shared vision does not mean scrutiny and improvements weren't required. They were, and our Scottish Parliament did its job, with extensive consultation that put the views of children and young people at the heart of what we were doing. Presiding Officer, the best of this place isn't always when there's highly polarised political views being debated. It's also when we work together for a shared goal or ambition. I'm very proud of the work that my committee, this Parliament and the SNP Scottish Government have done in bringing forward this bill, scrutinising it, working together on amendments that will improve it for our children and young people. Scotland is leading the way here with the passage of this bill. We're on another step closer to realising our shared ambition of making Scotland the very best place to grow up. Another young person told us, There's no difference in talking to a child or an adult in terms of how seriously you need to take our rights. I'll be very glad to vote for that tonight and commend the bill to the Chamber. Thank you.
Thank you very much, Ms Maguire. And I call Joe Fitzpatrick to be followed briefly by Gillian Martin. Mr Fitzpatrick.
Thank you, Presiding Officer. I'm delighted that Scotland is set to become the first country in the United Kingdom to directly incorporate the UN Convention on the Rights of the Child into domestic law. It's crucial that we, as MSPs, engage with and listen to young people. The Committee and the Scottish Government have both sought to ensure that the voices of children are heard throughout the bill process. Earlier this year, I met virtually with Dundee's Scottish Youth Parliament representatives, and I'd like to share with you some of their thoughts about the importance of this bill for Scotland's children. Ravati Campbell, MSYP for Dundee West, told me a human rights-based approach has the fundamental principles of participation, accountability, non-discrimination, empowerment and legality. The UNCRC incorporation will be instrumental in ensuring that these values are upheld in all political architecture concerning children and young people's rights. Through a leading piece of legislation that goes further than any other country, Scotland will be a beacon to the rest of the international community on respecting and upholding the rights of children and young people. She says it is crucial that the UNCRC reaches those from all communities and hubs, not just those engaging in certain environments. Our hope is that this will have a ripple effect on culture surrounding children and young people's rights. Salman Ismail, MSYP for Dundee East, told me that there are so many articles in the UNCRC bill that ensure every child is protected and offered the best and most optimistic route in life, but the one closest to his heart is Article 2, the Non-Discrimination Act, where every child must not be judged based on their skin colour, gender, religion, language or their family background. Lucy Angus, who's also MSYP for Dundee East, told me that full incorporation of the UNCRC is absolutely crucial for Scotland's young people. She said that the COVID-19 pandemic has created unprecedented challenges, particularly for young people, and that this bill ensures that we are not put in detriment and our rights are protected during this time and in the future. I also heard from Iman Hussain, Dundee West's newest MSYP, who's just come into post this month. Iman told me that as a young 14-year-old, she thinks that this is an important step. The law will help with the aim of the Scottish Government to protect and values the rights of children and young people in Scotland. This meets the desire for Scotland to be the best place in the world to grow up. She says the bill has a human rights approach, which is an important step, as it's not just talking about it, but actually legal action which demonstrates to young people that the government values their life, liberty, quality, education rights, and most importantly, their opinions. She says this feels like a more instrumental change and shows the people in charge are listening. Scotland can be an international leader in children's rights, she says. Adults can learn a lot from young people. Presiding Officer, I'm sure that members will agree with Iman that we do indeed have a great deal to learn from our young people and that we must keep listening to them. I'm very grateful to Iman, Ravati, Lucy and Salman sharing their thoughts on the bill with me, in order that I could share them with you to ensure that the voices of young Dundonians are heard here in our national parliament. The bill will put power into the hands of our children and young people and reaffirms our commitment to make Scotland the very best place in the world to grow up. Thank you, Presiding Officer.
Thank you very much. And I call Gillian Martin, then move to closing speeches. Ms Martin. I don't think your microphone's on.
Thank you. It is now. Thank you, Presiding Officer. I was pleased to be in the Equalities and Human Rights Committee as this bill went through. The journey of the bill to incorporate the UN Convention of the Rights of the Child is a great example on how Civic Scotland, the Parliament and Government can work together in the best and most inclusive of ways. And it's fair to say that the campaigning efforts of young people and children's rights organisations across the whole of Scotland has been fundamental to getting us to this point today. I particularly want to pay tribute to the work of the Scottish Youth Parliament, who have for years campaigned not just on the necessity for this legislation, but have, as individuals, informed and engaged young people in their own communities throughout Scotland on these issues. Throughout my time in the Equalities and Human Rights Committee, I've been chatting to the two MSYPs in Aberdeenshire East, Shane O'Mall and Finn Dixon, who are pupils at Inverurie Academy and Ellen Academy, respectively. Both of them have talked to me about how important the UNCRC incorporation is to them and of the work they've been doing with their peers to ensure that children's rights are communicated and discussed as part of their everyday lives. They and many other young people I spoke to also highlighted the importance of the UNCRC right in particular to be heard and to have their views taken seriously in all matters affecting them. And key to this is having the knowledge of your rights and an understanding of the options open to them in any situation and knowing about decisions made that affect them. I was pleased to be able to make some amendments at stage 2 which strengthened the requirement for child-friendly communication of reports relating to them. And I was prompted to propose these changes after attending our committee's many outreach sessions with children and young people. In particular, I'd like to commend the care-experienced young people who spoke to me about the times in their lives where they have felt that they weren't made aware of their rights or haven't been given the information in a way that was comprehensible to them, or indeed at all. One care-experienced young man reflected on times in his life when he wasn't informed enough to ensure his views were taken into account over decisions about where he should live. And a young person with the experience of the justice system told us a lot of professionals automatically assume, as young people with lived experience, that we know about our rights when we don't. Now is the time for every organisation to look at their processes and procedures and ensure that children's rights are embedded, communicated and respected. Certainly, an area that I know our committee colleague, Mary Fee, has done a lot of work in is with the families of prisoners, and particularly in the rights of children to see their parents. In my area, we have a situation where local councils have reduced or withdrawn funding to the Family Centre HMP Grampian. And I've been arguing for that funding to be reinstated to allow the centre to be open at its fullest capacity with child-friendly facilities and people that prepare children for experience of visiting prison and provide support for families. I will be again challenging these short-sighted funding decisions with a children's right perspective with the wind of the UNCRC incorporation at my back. We are, amongst other things, about to vote tonight to ensure that there is a legal duty on Scottish ministers to carry out and publish a child's right and wellbeing impact assessment in all legislation from now on. Everything we do must be compatible with the UNCRC. Everything. It's a watershed moment for Scotland's children, and I know many of them are watching us today. Presiding Officer, it's a great bill. As Ruth Maguire said, this is a joyful moment, and I'm proud to support it tonight on behalf of the children in my constituency of Aberdeenshire East. Thank you.
Thank you, Ms Martin. And I now call on Mary Fee to close for Labour. And Ms Fee, this is your ultimate speech.
Thank you, Deputy Presiding Officer. And yes, let me give you the reassurance and give the Chamber the reassurance that this is definitely my final contribution to a debate in the Scottish Parliament. And I would like to use some of my time to reflect on my 10 years as a member of the Scottish Parliament for West Scotland. It has truly been an honour and a privilege to represent West Scotland since 2011. And my time in this Parliament has aligned with many positive moments and progressive changes. In many aspects, Scotland has come a long way, yet there is still far more we can do on equality and human rights issues. As most will know, I have placed equalities and human rights at the core of what I have done. And my ambition to create a more equal Scotland has been a driving force in my long political life. And protecting the rights of underrepresented groups such as the LGBT community, gypsy travellers, black and ethnic minorities and families of prisoners has been a mission that I have held close to my heart, and I am thankful for the opportunities that have arisen to put my beliefs into action. And Deputy Presiding Officer, of all of the votes that I have cast in this chamber, the two that I am most proud of are the votes in favour of the Marriage and Civil Partnership Scotland Act 2014 and the Historical Sexual Offences, Pardons and Disregards Scotland Act 2018. These promoted equality for LGBT people and tried finally to make amends for the horrors of the past. I also want to place on the record my gratitude to the many colleagues from all parties who have been a source of constant support and friendship and continued to motivate me to do better for not only West Scotland, but for all of Scotland. I'd like to take this opportunity to also thank all of the Parliament staff, especially the clerks, the security and the catering teams. Without the staff that assist us in this place, this building simply could not function. And, Presiding Officer, without a doubt, the last 10 years has been a journey for me. And it's a journey that would have been so much more difficult without my staff. So I want to place on the record my thanks to Angela, Gareth, Dan, Rory and Zoe. I can never thank you enough for your hard work and support. And, Presiding Officer, coming back to the passing of the United Nations Convention on the Rights of Child Incorporation Bill, we have had a very consensual debate today. It has been a short debate, but it's been a very consensual debate, and one that has demonstrated the willingness of members from across the chamber to improve the lives of children now and for the future. We will become the first nation in the UK to legally enforce the rights enshrined in the UNCRC, showing again that we can use the powers of this Parliament to lead. With devolved powers in our hands, we can put that power into our children's hands. This bill has been one that may have come later than I personally would have preferred, but it is timely as we recover from the pandemic and ensure that the future of children and young people are protected and their rights are guaranteed. There were many children's groups and organisations that the committee heard from, and I am delighted that we get to pass this bill today for them and the voices that they represent. And finally, Deputy Presiding Officer, it is my sincere hope that the next Parliament is one that rebuilds our society to make it more fair, more equal and more protected. I would like to see the next session of Parliament continue the work to improve the outcomes and end the discrimination of gypsy travellers, to further support families of offenders and make meaningful reform to our criminal justice system. I'd also like to finally see an end to the discrimination our trans community face every single day just trying to lead their lives. And as the focus of today is children's rights, I also hope that progress can be made in raising the age of criminal responsibility, treating children as children and not as criminals. And finally, and this is definitely my last finally, Presiding Officer, I hope the next Parliament...
I'm not timing you. Go ahead.
I hope the next Parliament continues the work to make our society more fair, more equal and more protected, and that the members that remain here are a positive example of how we can enhance equality and protect human rights. And I said in my opening remarks that the best parting gift I can give is empowerment, protection and respect to our children by passing this bill today. And I cannot overemphasise the importance of this legislation, and it truly will be a privilege to vote for it tonight. Thank you.
Thank you very much, Ms Fee. You will be missed. You'll be missed. I now call on Jamie Green to close the Conservatives. Mr Green, please.
Thank you, Deputy Presiding Officer. I'm really grateful to have the opportunity to speak in this Stage 3 debate. Can I start by offering my thanks to the Equalities and Human Rights Committee for steering this critical piece of legislation through our Parliament. I do miss the committee a lot. We shared some great experiences and I made some friends in that committee. One of them, I believe, Mary Fee. I get the opportunity of saying thanks to her for her final speech, not her penultimate speech. But I think it's really important we place on record as a Parliament our thanks to Mary and people like Mary. It was just last week we heard from Ian Gray in the redress bills. And I think it's, people like myself, new members to this Parliament, despite our many political differences, I've learned so much from other members, especially those who've been here for multiple terms. And I know Mary's work on transgender rights, on the Gypsy travelling community, I share many of her aims and ambitions there, but specifically those 2 votes that she mentioned, that she's so proud of, that affect my community and people like me. I haven't been able to take advantage of the one on civil partnership, but maybe one day I will. But thank you, Mary, for everything. Thank you. I hope that's on the official report as well. And that leads me on to the very essence of what we're doing here today. It was only last week that we did pass the redress bill, another piece of historic legislation that sought to right wrongs of the past. But that was to right wrongs of the past. This bill is different. This bill is about the future. I think it shows the positive change that we can make if we work together. The UNCRC bill is similar in that regard. I just hope that when we do return from the weeks of intense campaigning and differences of opinion that face us all in the coming weeks, that we do come back and reflect on those positives. Because having full cross-party support for a bill like this, I think is important. It sends a signal. Because this legislation, given that it will enshrine articles set out in the UN Convention of the Rights of the Child into Scottish law, it is a clear example about how this Parliament can go above and beyond. The UK has a proud tradition of championing international human rights and global conventions, way back before this Parliament itself even. The UK not only helped draft the European Convention of Human Rights, but was one of the first countries to ratify it way back in 1951. Decades later, the UK passed the 1988 Human Rights Act, which transposed European court rulings into our own domestic law, something which many European countries are themselves yet to do. And to this day, we still play a leading role, and I hope we will do so, in the Council of Europe and the United Nations Economic and Social Council, which govern many of our human rights frameworks. But the UNCRC is different. It is different because of the relevance to its key 4 pillars and devolved powers. Those key 4 pillars: non-discrimination, the right to survival and development, the interests of the child, and the views of the child. And I think the events of this past year have shone a light on all of those. It doesn't just cover, it's not just a framework which covers the rights of a child. It isn't just a convention that we're ratifying, because the convention itself has been around for 30 years. But we know that so many children, even in the developed world, are still being let down. UNICEF themselves say it's up to our generation to demand that leaders from government, business and communities fulfil their commitments to take action for children's rights now, once and for all. They must commit to making sure every child has every right. I don't disagree with anything in that, but we must recognise that just passing legislation is not an end in itself, and further efforts are needed by all of us. We cannot let this be a debate where we pat ourselves on the back too much. Passing law is one thing, making a difference is another. It is what we do which matters, not what we say. And the decisions that we've made this past year, they've been difficult ones. I've sat here on many occasions and struggled with the decisions we've had to make and the effect that that will have, knowing the effects they will have on young people, whether it was the closure of schools or nurseries, whether it was the unfortunate delay to childcare, whether it was the delays and backlogs in children's panel hearings, or, as we now know, the rise in domestic abuse and violence, or the mental health crisis which awaits us at the other side, the closure of outdoor learning centres, the SQA's decisions around exams, the drugs crisis, the quality of our housing. These are all issues that both government and its agencies, some of which I admit are outside of the control of government, play into the lives of children. One does have to wonder how any of this, or if any of this, would have been handled differently if this bill had passed a year ago today rather than today. Because we cannot and we should not underestimate the substantial impact that this pandemic has had on young people, which is why this bill is so important. We know that children are not necessarily the face of the COVID pandemic, but they are risking becoming its biggest victims. Presiding Officer, I'll close by saying that these benches, I hope, as has been demonstrated throughout this process, will work constructively and positively with anyone in this Parliament. It's an issue way above politics, outside of traditional party lines. It's something that means a lot to us personally, which is why I support the bill today. But as I've said, our job doesn't end there. Talk and action are two very different things. I'm really pleased to support this bill, but I do hope this next Parliament goes way beyond talk and does more action.
Thank you very much, Mr Green. I call on John Swinney to close the Government. Cabinet Secretary, please.
Thank you, Presiding Officer. It's an enormous pleasure for me to close this debate on behalf of the Scottish Government. And, Presiding Officer, I don't think it will be a revelation to Members of Parliament if they realise that not every day for me is a good day. Sometimes there are very, very difficult days. Well, today is a very, very good day. And it started off really well with a meeting of the Cabinet. I don't always say that about meetings of the Cabinet, but it was a special meeting of the Cabinet because it was the annual meeting of the Cabinet with children and young people in Scotland. And members of the Cabinet listened with care to the issues raised with us by young people. They raised with us their concerns about racism in our society, and went through a little exercise with members of the Cabinet, which I was horrified to find out that from my experience of the education system in Scotland, I was at the wrong end of the spectrum in terms of my experience of how my education was structured in terms of the understanding of the questions of race. They talked about the mental well-being issues that many young people face, and members, colleagues across the spectrum have talked about these issues as a consequence of COVID. They talked about digital poverty, and they challenged us about our agenda on climate change and what more we had to do, with a super idea about plant a tree day for every one of our citizens to go and plant a tree. And, well, that would get us about 5.5 million trees in one afternoon if we could all get round to doing it. So, wonderful ideas. But for me, the whole essence of the conversation was captured by the contribution of a young man and member of the Scottish Youth Parliament for Kilmarnock and Irvine Valley, Liam Fowley, who sits on the Education Recovery Group and who sits with us every week, every Thursday morning, and makes a contribution on behalf of young people on the issues of education recovery. And Liam said this to the Cabinet this morning: make young people part of the thought process, not an afterthought. Make young people part of the thought process, not an afterthought. And that strikes me as a particularly good comment to sum up where we've reached as we edge towards the end of this very good day for Scotland, and this certainly very good day for the Cabinet Secretary for Education and Skills in comparison to other days. The bill, that brings me to the bill that's before us this evening. And bills start off with that initial rather tentative conversation with the bill team, where they largely say to ministers, what do you want to be in this bill? And you have to set out your instructions. And Patrick Harvey put his finger on it when he used the word maximalist. That was the direction I gave to officials at the start of this process. This bill was to be a maximalist bill. We were to do all that we could within our legislative competence to protect the rights of children and young people through the incorporation of the United Nations Convention on the Rights of the Child into Scots law. And I'm glad that Patrick Harvey acknowledged that point, and I think it's been shared across the Parliament in the debate that we've had this evening. The bill has undoubtedly, and I said this also last Thursday when I closed the debate on the Government's behalf in relation to the redress bill, the bill has been strengthened by parliamentary scrutiny, and in that respect I pay tribute to the Equalities and Human Rights Committee and its convener for the scrutiny that they have presided over in relation to this bill. At all levels, whether that was about the detailed line-by-line scrutiny or the committee going out of its way to engage children and young people on whatever time of the day or the Saturdays to make that happen, essentially living out the point that Liam Fowley was making about make young people part of the thought process, not an afterthought, and the bill has been strengthened as a consequence of that. So I thank the committee for that. And I reinforce a point that I made on Thursday night as well. This Parliament gets a lot of criticism and a lot of stick from people who deride what goes on here. But actually, there is a phenomenal amount of very good, detailed work undertaken by members of Parliament of all political persuasions that enhances the law of our country or the scrutiny of particular issues that we have to face. Now, of course, passage of a bill is one thing. We then come to the point that Jamie Green fairly raises in his summation for the Conservatives, and I welcome Conservative support for this bill, is about the implementation and what does it result in. And if I was to put one test on this to set up the ground for future scrutiny in the Public Audit Committee proceedings in the years to come, it has to be about whether there's a culture change in institutions in Scotland about how we consider the rights and the perspectives of children. That will be the measure. Now, there'll be a few challenges about how we actually document and measure that, but that will be the measure of whether this has been successful or not. But undoubtedly, the implementation is the critical next step of how we take forward this bill. But we've arrived at this moment, and the Minister made a number of remarks in her opening comments about those who have contributed to this journey, but one of the people who's contributed phenomenally to this journey is Mary Fee. And I'm glad that I have the opportunity on the Government's behalf to pay tribute to Mary Fee at the conclusion of this debate. Mary Fee has been a tenacious campaigner on behalf of children's rights and of all aspects of the equalities of our citizens. And she mentioned, and I think this, in a sense, Mary Fee mentioned three particular themes of her activity, which have been around protecting the position of gypsy travellers, about supporting transgender citizens, and about protecting the families of prisoners. And if I could select three particular campaigns, and I don't say this in any way disrespectfully, that are not exactly mainstream or there's not a queue of people to lead these campaigns, it would be perhaps these three themes. And I think that says everything about Mary Fee's willingness to reach out for individuals that society doesn't always do an awful lot to reach. And that is, I think, what I would want to say to Mary Fee, and paying tribute to 10 years of distinguished service on behalf of her constituents in the west of Scotland, but more particularly influencing debates about the rights of individuals, about equalities, and about, crucially in this bill, respect for children, which is where Mary Fee concluded her last speech in Parliament. So I extend to Mary Fee the warmest wishes of the Government, and I know that's supported by all members of Parliament. This journey, of course, has involved many people, and it's taken the Government a long time to get to this point. The foothills of this journey were led by my dear friend and colleague Michael Russell, who is sitting behind me. I can't always say he's been behind me over the years, but he's been behind me more often than not over the years. But Michael has been a friend, ally, colleague and confidant of mine for the best part of, I'm now trying to do a sum in my head, presiding officer, over 30 years. And ever since I first declared his election to national office in the SNP by a margin of 1 vote, I seem to remember, in 1987. But Michael Russell is standing down at the election, and this is an opportunity for me to pay public tribute to his enormous service to this Parliament and to my party, and to recognise the contribution that he has made from many perspectives, from the literary depth that he brings to his contributions, from his analysis of issues, and for his wise counsel to Parliament. He was accompanied in the foothills journey on this bill by Aileen Campbell, who also stands down at this election. And I've had the pleasure to work with Aileen as a cabinet colleague and also to represent her dear parents in this Parliament, who are friends and constituents of mine. And I pay tribute to Aileen Campbell for all that she has done to lead the debate on children's rights, and I wish her well in the future. On this bill, presiding officer, much has been said about the role of stakeholders, but I do want to say something about the role of UNICEF, about the role of Together and the role of the Children's Commissioner. They have been tenacious in bringing forward the arguments for this legislation, and they've played a constructive role in making sure this legislation could be as strong as it possibly could be. And I express on the Government's behalf our profound gratitude to them for the contribution that they have made. Bills do not come about by accident. We've been supported by a fantastic bill team of civil servants who've worked on this very complex bill with diligence and energy and have engaged constructively, and I thank them for that. I also want to say that my portfolio has had to deal with two sizable bills in the course of the last 10 days. I have been hugely supported by the Children's Minister, Marie Todd, who's given exemplary leadership to this process, and I am enormously grateful to her for all that she has done. Presiding Officer, I'm grateful to you for indulging me with a slightly longer speech, but it's coming to the very last part of it just now, Presiding Officer, you'll be relieved to hear. When I get home tonight, assuming that bedtime has been avoided again, I would think, I will be asked the question, what did you do in Parliament today, Dad? And it will be a source of enormous pride that I can answer that question by saying, well, Matthew, I, along with my colleagues, voted into law the articles of the United Nations Convention on the Rights of the Child. And there is something quite simply legislatively beautiful about incorporating the schedule of this Act into Scots law, to translate into our domestic legislation these fabulous words developed around the world, given to us through the United Nations to say to all of us, this is what you should do if you want to make sure your children have the greatest opportunities and the greatest protection in their life. And members of this Parliament who have laboured on this question for so long should be able to vote tonight with enormous pride in what they are doing to safeguard the interests of our children in the future. And we need to live up to the words that we've put into statute tonight to protect children and young people and their best interests in the years to come.
Thank you very much, Cabinet Secretary. That concludes the debate on the United Nations Convention on the Rights of the Child and Corporation Scotland Bill, and it's now time to move on to the next item of business after a short pause.
Thank you, colleagues. Now, given the time, I'm minded to accept a motion without notice to bring forward decision time to now. Could I invite Patrick Harvey as a member of the Bureau to move the motion?
I so move.
Thank you very much, Mr Harvey. So I'll put the question. The question is that decision time is brought forward to now. Are we all agreed? Yes. We are agreed. Thank you very much. Now, before we come to decision time, could I just ask, I'm not going to suspend business, but could I ask members to refresh their voting app? So you don't have to put in the code again, just refresh. And it should refresh on the last vote that you are engaged in. And anybody that's joined online, perhaps if we put the pin up online in the blue jeans. Thank you, yeah. Function. Thank you, colleagues. In that case, I think nobody seems to have indicated any difficulty, so I think we're going to go straight to the vote. There's only the one question this evening, but it's on legislation, so we are going to vote. The question is that motion 24369, in the name of John Swinney, on the United Nations Convention on the Rights of the Child Incorporation Scotland Bill at Stage 3 be agreed, and members may cast their votes now. This is a 1-minute division on the UNCRC bill. That vote is now closed. Please let me know if you were not able to vote. Point of order for Gil Pattison.
Hello, Presiding Officer. I'm afraid my app wouldn't work this time. I would have voted yes, of course.
Thank you, Mr Pattison. That will be noted. Your vote will be added. Point of order from Anas Sarwar.
Point of order, Presiding Officer. My apologies. I wasn't able to log into the app and I would have voted yes.
Thank you, Mr Sarwar. Your vote will be added. Thank you very much for the point of order. Thank you. The result of the vote on motion 24369 in the name of John Swinney is yes 114. There were no votes against, there were no abstentions. The motion is agreed and the United Nations Convention on the Rights of the Child Incorporation Scotland Bill is passed. Thank you, colleagues. That concludes decision time. We're going to move on shortly to members' business. Before I do, just remind members when leaving the chamber just to be careful to observe social distancing rules, wear your masks and follow the one-way systems. And we'll turn in a second to members' business in the name of Jackie Bailey on support for people with learning disabilities during the COVID pandemic. Just a short pause before we do.